we should have Ms. McLean. Ms. McLean's on the line. Can you hear me, Ms. McLean?
Yes, I can, Your Honor. And
Right.
I think Ms. Ernest is also present.
Yep, Ms. Ernest is present in the courtroom next to her client, Mr. Stout. And is your client, Ms. Stout, on the line with us today?
No, she's not.
Okay, great. All right. Today's purpose of the hearing is to just review if the contempt had been purged. Back on May 8th, there was a contempt order entered, and the purge contempt conditions were, excuse me, payment of spousal support and interest related to that, the FERS pension payments, and the January, February health insurance costs, and that life insurance is in place with Ms. Stout as a beneficiary. Anything to add to that, Ms. McLean?
So currently, Mr. Stout is current in his payments. I'm aware that Ms. Ernest has been assisting him in contacting OPM, trying to receive information relative to the insurance. And I understand that the government can be fairly slow. So we're willing to kick this over for 2 more months to see if they respond to verify that my client has been listed as the beneficiary.
Okay. All right. Thank you. Ms. Ernest.
Not agreeable, but we agree on that.
Okay. All right. Thank you, Mr. Stout. Appreciate that. So we will continue things over to, let's see, October.
November. How about November 13th? That way we've got some leeway, and assuming we receive the documentation verifying, then we can just strike the hearing.
Okay. Ms. Ernest?
That's agreeable to us as well.
Great. We'll set the matter to November 13th, 9 a.m. Strikeable if it's everything looks okay.
Perfect. Thank you very much for taking this first, Your Honor.
The line,
You're welcome.
like we have
All right, thank
Ms.
you.
Russell representing the state. Mrs. Russell, can you hear me okay?
Yes, Your
Yes, I
Honor.
can hear you.
Okay.
Oh.
And then Mr. Lester, I see that you're on the line. It sounds like you can hear me just fine.
Yeah.
All right. Very good. All right. We're on today for, looks like a finalization. There was a petition filed, an amended petition that was signed with a joinder by Mr. Lester. And
Yes.
looks like the courthouse facilitator reviewed the pleadings. According to her review, everything seemed to be in order. And I guess the only thing that the only disagreement or maybe differences would be in the child support that the state had filed. So let's just finalize the parenting plan, make sure everybody's comfortable with that. Mr. Lester, you reviewed that, and do you feel comfortable with that parenting plan that's been submitted?
Every other weekend in a month out of the year during the summer. Yeah.
So what I have is that the Ms. Lester is designated as the primary custodial parent, and that your residential time would be alternating weekends from Friday at 4 to Sunday at 5 p.m. Does that sound right?
Yeah, but that's got to be flexible, Your Honor, because I mean, I am a construction worker, and you don't always get out at 4 for pickups, but she's lenient on my pickups, so I'm fine with it.
Okay, and then I think the summer visitation was 4 weeks each for summer vacation. Is that accurate?
Yes.
Yes.
I've been giving her to him every weekend, like I'm pretty lenient on it.
Okay, all right. All right, so it sounds like both the parties are in agreement as far as the parenting plan. All right, and then let me just double check with the parties. First off, Ms. Russell, you had submitted some child support worksheets and the like based on employment data information, where you set the net incomes at $44.55 for Mr. Lester and about $20.17 for Ms. Lester. You want to elaborate further on that and maybe point out any differences between your figures and the figures submitted by Mr. and Ms. Lester?
Yes, Your Honor. Primarily, the biggest difference that the state is concerned about is the lack of medical language in the order proposed by the parties. There is both state medical coverage and TANF in this case. I'm also a little bit concerned that Mr. Lester's income is overestimated in the parties' worksheets. It may be correct currently, but it looks like his employment is sporadic. I expect he's a union worker, and while he makes exceptional hourly wages when he is working, he doesn't have consistent full-time hours. So what I did is for my worksheets is I averaged the last calendar year of his earnings overall, including unemployment for those times when he was not employed. And it's not been very many weeks he had unemployment, but looking back over his employment history, he is better situated now for hours than he has been in the past. And my concern is that it's a little bit overestimated here for a right-sized quarter, although that's something that the parties can argue. To summarize the order overall, there's one child, Paige is 8 years old. Parties are Ryan and Lynn Marie Lester. The actual income averaged over the last year for Mr. Lester is gross about 5239, net 4455. Lynn Marie is also a little bit higher than the statutory imputation in 2619.075, and because she's receiving TANF, it would be a little bit lower than that, which would put her at a gross of 2240 and a net of 2017. There's currently an administrative order in place. It's about $550 a month. I don't have that directly in front of me. And they're looking, the parties' numbers would bring the transfer payment to about $1,000 a month, and the state's worksheets would bring it to $744. The state is asking that this order began on July 1st because that is when the TANF began, although there is an administrative order in place. The state would like to see that be based on current income starting in July, based on RCW 7420-220 and the state's obligations under the Social Security Act. Also, I would ask that if there's any deviation from a standard calculation based on agreement of the parties, that it also have findings related to their financial situation, consistent with RCW 2619.075. And so we would ask that the court enter a child support order today, and at a minimum include the state's language in paragraphs 20 through 22. Thank you.
Thank you. Let me hear from Ms. Lester regarding your view related to the child support, the incomes and the like.
This last year, Ryan has spent most of the year in treatment for alcohol. The rest of the year, he's been at his mom's house, purposely not trying to help her pay child support. He just started going back to work as a pipe fitter, or so he says, I'm not sure. Making good money. He spent at least 6 months of last year in treatment in Florida. That is why we're not together. And he just recently, last week, offered to help with school supplies, bought all 3 children some shoes, bought our daughter a backpack, claims he's sending some money on Thursday to help with school supplies. Other than that, I have not received any help from him. I have not been able to come to an agreement with him. We had an agreement. He said he wanted the judge to decide. Keeps bringing it up to check his last year payments, but he wasn't working because he was in treatment or at his mom's house. So usually he's a good worker and he works all the time, and he just hasn't wanted to help. So I've done what I can. I've always paid the bills. I've always paid the rent since the last 2-3 years. So I just do what I do for my kids.
Okay. So there were some different numbers you had, I think you and Mr. Lester had set forward that Mr. Lester's net income was about 6,500 and yours was about 2,100. The state's representing that his net income should be about 4,450 and yours should be about 2,000. Do you have any input on that?
I'm not aware of how much money he makes right now. I have been with him when he worked a similar job where he was bringing in about 3,000 a week. Hence why I figured he started helping with school supplies and backpacks and things like that, was because he was making good money. I know that he's renting his own house up by where he works and also stays with his girlfriend in Centralia when he can. So, I mean, I don't really know anything about his work history right now or his life, just when he sees our daughter. That's my only business with him.
Okay. All right. Thank you. Mr. Lester, what's your vantage point as far as the child support issues? You know, numbers that you've
My vantage point is I would agree with what the state says because that is correct. And I'm a union worker. It's about to start raining and we're about to stop working. You know, we take layoffs. It's the way it is. When you do concrete, you don't work in the rain. When you work the pipelines, you don't work in the rain. They are correct. They did my last year's wages. We can base it off of my last 5 years' wages. They're about right on right there. So what she quoted, the 700 something a month, I'm good with that.
Okay.
Because I'm gonna have to live off of unemployment here coming soon and still have to pay that. It's not, you know.
Okay. All right. Thank you.
He's also stated that he's going out of state so that he can keep working on here.
Okay.
Yeah, my next job out of state is only going to give me $20 an hour, and that's minimum wage in Washington. I'm going to Montana where they don't pay as much, and I still have bills to pay here. So, And I'm gonna have
Your
to
Honor,
rent somewhere over
if I
there.
may add some detail.
Thank you, Mr. Lester. Appreciate your input. Ms. Russell?
I just wanted to add some detail. I went through and summarized the hours that Mr. Lester had worked per quarter on an average basis weekly. And he's currently at only 31 and a half or so for the last year. And that's the highest it looks like he's ever been. But that's at close to $40 an hour. And I think it unlikely if we imputed higher that he would be able to earn that. Like Mr. Lester said, if he were to make up those hours and work, it would be a lower rate than what he makes as a union worker. I don't think that a skilled laborer outside of a union, if they're not working in their trade field, as they're prevented from doing by their union contracts, that he would be making his trade wages.
Okay, thanks, Ms. Russell. Well, I appreciate the input from each of the parties. Taking a look at the incomes, I think I prefer the approach that's been presented by the state in that they're looking at historical data and kind of an average over a period of time. I think that gives us a fair estimate of what the incomes are. So I'll adopt those numbers and use the numbers of 4,455 net for the father and 2,017 for the mother, which results in a net, a child support payment of $744 per month, 744. I'm going to have that start on August 1st. And I'll ask Ms. Russell in the proposed order, just make sure I don't miss this as far as the date that is included on which paragraph in your order.
I
Hey,
don't
Your
know.
Honor.
So, sorry, Ms. Russell, go ahead.
Oh, I don't know that one off the top of my head. I'll have to find it. I
Okay,
want to say about 14-ish,
so let me look there. Okay,
11.
11, thank you, good call. So I'm just going to cross out July and just put August 1. And so I've signed off on that child support order and also the child support worksheets. Then the other matter that we have are the proposed orders are related to the marriage. So there's findings and conclusions of marriage that looks like has been signed off by both Ms. Lester and Mr. Lester. There's also a final divorce decree, and then there's a parenting plan that's been presented that's been signed by both Mr. Lester and Ms. Lester. So earlier we talked about that. It sounds like the parties were in agreement with that. And any further questions or discussion on that? Otherwise, I'll just go ahead and sign those.
No.
Okay, Mr. Lester.
No, sir. I have one question on the child support. Since you started it August 1st, they've been taking money out for child support out of my check already. So what do we do about that?
Ms. Russell, do you have any insight on that?
There is an administrative order in place. It is for $554 a month. So Mr. Lester will owe a balance of $190 for the month of August, in addition to what's being withheld.
Okay, does it help, Mr. Lester?
Yes.
Okay.
Okay.
And generally, he can call and arrange with DCS at the rate at which he repays that bit of arrears also. It looks like he's roughly about $800 behind right now. It's not a great deal of arrears.
Okay. Well, Lemery Lester's working right now, so I don't know why she's still on TANF.
Generally, it takes about 6 weeks for that to catch up.
Oh, okay.
Okay. All right. So the proposed orders, I've signed off on the dissolution decree, the findings of fact, also the parenting plan. So if the parties need copies of that, you can check with the clerk's office and get a copy of them. And then otherwise, the child support orders that were presented by the state, I've signed off on both of those, the order and also the worksheets. So I think that we've accomplished everything that the parties had presented for discussion today. So I think that concludes the hearing. Thanks for being here.
All right. Thank you.
And Ms. Adelpha de Dios, can you hear me?
Yes, Your Honor.
All right, very good. We're here today for a presentation from the bench trial that we had not too long ago. Let me just pull up the proposed orders.
Yes, Your Honor.
All right, so it looks like Ms. Hoke prepared a proposed order and forwarded that to Ms. de Dios, and Ms. de Dios looks like she filed it looks like it was more of an email exchange where you indicated the concerns of the proposed order. So I have that email in front of me, and I also have a Department of Licensing affidavit of loss or release of interest related to the Lexus. So let's take a look then. I have two documents. I have findings and conclusions about a marriage and also a final divorce order or dissolution decree. So let's just go through the list here. Ms. Hoke kindly prepared those. And then I see Ms. de Dios, you had it looks like a series of, let's see, 1, 2, 3, 4, 5, 6, 7, 7 items that you wanted to address. So maybe we can just go down the line and look at those. The first one that you mentioned is inclusion of interest incurred on the $12,000 awarded to you in the August 28th hearing to be subtracted from the 4,000. Go ahead and explain that a little bit to me, please.
Your Honor, even though it was not mentioned about the interest, but when the judge, when the Honorable Judge ruled that it concerns the award that was given to me last year in August 28, I believe, or 29, it was referring to the award, and my understanding is that it should include the whole in a phrase that covers that award, which says if it is not paid within 90 days, it will incur interest. So I was hoping that it could be stated also clearly on the document.
So, okay, and looking at the proposed document, is there a location where you feel that should go?
Yes, yes, Your Honor. It might not have been given to you. I put some numbers there. Regarding the whole, I'm not ready with the copy, Your Honor. Let me just find that out first.
While you're looking for that, I'll hear from Ms. Hoke. Ms. Hoke, related to Ms. Dedios is number 1 on her email.
Well, first of all, she was awarded $2,000, not $12,000 in
Oh.
temporary attorney fees. And the temporary order did not designate a due date or any interest. So we don't believe that interest is appropriate here. She didn't argue this at the trial. This is a new request. So because of the way you did the order, that $2,000 ended up being subtracted from the $4,000 in fees that you awarded to my client. So I don't think there's any legal basis here to attach interest to that $2,000.
Thank you. Let me ask Ms. Dedios. I'm looking at the August, or probably it's a September 8th, 2023 order. It says lawyer fees, $2,000. And it says interest, it says 00, and then there's an asterisk, which says interest to commence 90 days from hearing date on any unpaid balance.
Okay, that's my mistake.
Pardon?
That was my mistake then, Your Honor.
Okay. So I was just looking at that. And then Ms. Dedios, did you make any calculations as to what the interest is or was?
No, Your Honor, because I was never told until I asked the clerk of court, and I wasn't, we did not talk about how much is the interest, but the clerk of court explained it clearly that there was an interest. So I'm not able to compute it I didn't have that computation, Your Honor. I apologize for that. I don't really know the procedure because I'm self-represented now. So if we can just have a time to compute that, I really don't know the basis, Your Honor. I was never told by the lawyers, and except until I called the clerk after 2 months of not being able to receive any answer from the or a month from the lawyers, and then I called the clerk of court.
So
That was the only.
Ms. Dedios, since you're asking for the interest and it allows for that, and we were last here for the hearing or the trial back on August 9th, so there were roughly 12 days since the trial. I'm just curious, if you don't have a proposed number for me, I'm not really in a position to award that, even though the order allows for that. So if you haven't done that calculation, then I'm not going to include it, even though that the order says that. That's kind of your cart to push uphill, and it looks like that the cart's not being pushed. So,
Your Honor, may I also say something about what Ms. Hoke said? She said that it was not contested and it was not mentioned during the trial. It was, Your Honor, because the honorable judge went through my 5 requests during the trial, and when he was yes, he made the ruling on that without asking me. So there was no way I could contest it. The honorable judge just gave a ruling on that, not during the trial, but there were a lot of interruptions from them when I was testifying. So I'm not sure if they didn't hear it or they didn't catch it, because there were too many disruptions in the technically during that time. So
are you referring to the trial that took place earlier this month?
yes, Your Honor, the only one.
And it sounds, just making sure that you recognize that I was the judge that heard the trial, correct?
Yes, Your Honor.
Okay, I had kind of the impression you were talking about a different judge. So I was just making sure we're on the same page. Okay, all right. So Without having a figure provided to me, I'm going to deny the request for interest because I simply don't know what that is, and that's the responsibility of the parties to tell me what that amount is. So we'll look at number 2 on your paragraph. Number 2, it says, why July 7, 2023, when the legal counsel was hired in the filing of the case in February 2023. I'm not sure if I understand that. Could you please clarify that for me, please?
Your Honor, can I just do away with that? I guess it will not be relevant anyway, but
Okay.
I just,
I'm going to strike that one.
thank you.
Okay, number 3 says in number 6, I think you're making reference to one of the proposed orders of Ms. Hoke as far as a paragraph. It says we were in communication in April 23. The respondent insisted to give my location to pick up and to reconcile. Nothing of the summon or divorce was heard. Divorce is a right, and he filed for it, but never admitted to it. Can't give him the address unless he admits to filed divorce and serving the summons, but he didn't. I asked what we should do together to cooperate, but he refused. He never told me about complaints. So I'm looking at paragraph number 6. That's the money judgment of the $2,000 that was awarded previously, and that was extinguished by virtue of the balancing of the attorney fees. So I'm not sure what the net effect of your number 3 is. What is it that you want the court to do with number 3?
Your Honor, the words were just not it says that it was like I admitted that that I did not that I stalled on his time, but I heard you say that that was granted to him because yeah, that I stalled his time. And there were extra words in it, but if ever, I'm also willing to disregard that, Your Honor. Anyway, I made a concise one, and I only have 4. So I only have 3. I mean, in all my requests, instead of that 7, I concise it into 3. So I might as well disregard that, Your Honor.
Okay.
Apologize.
All right, we'll do that. And your paragraph number 4 says, in number 14, I do not speak Korean for a long time. I did in the 90s. So I'm looking at paragraph 14. Paragraph 14
Yes.
doesn't have any reference to the Korean language in either of the proposed orders. So I'm not sure what you're trying to say there.
Well, it says because I speak Korean, Your Honor. I know
Does
that.
it say that in the proposed order?
Yes, it was in the proposed
Where?
order.
I'm asking where does it say that?
Your Honor.
Ms. Hoke, did you include that in your proposed orders? I looked and I didn't see it.
I am not seeing it, but I think it would be in the findings, so I will check
Okay.
those, but it's not in number 14 on either document. I can see that.
So we're looking at the findings here.
And I was not tested, Your Honor, to prove that I speak Korean because I don't remember us mentioning about that, Your Honor. The Korean language, I mentioned about therapy of my vocal.
So I'm not seeing it in the findings and findings of fact. It'd probably be in paragraph number 22, and I'm not seeing anything there. Oh, there it is, 22C. Respondent speaks Korean. I think probably what we would probably say there that the respondent speaks a low level of Korean language.
I no longer practice it, Your Honor.
Right, I understand that. That's the finding of the court that you testified to that at the trial. So I'll just out Korean. I'll speak and say respondent speaks a low level of the Korean language.
Okay, Your Honor.
Great, thanks for raising that. I appreciate that. And then we'll take a look then at number 5. It says your paragraph number 5 says fainting 3 times out of anxiety is not unnecessary, especially when it happened frequently and with medical history for 4 years. Is that reference to the fainting, the anxiety, is that included with any of the proposed orders?
Yes, Your Honor, for the AMR.
Okay, so we're looking then.
Because it says, Your Honor, nothing, but I didn't hear you say nothing. You said, although you said that even though the AMR find it okay, and I still insisted. That was what I heard from you. So I just want the nothing to be changed, to be reflective of the judge ruling and not on the side of the other party.
Okay, so it looks like there's a reference under paragraph 22 of the findings under 22I and 22I. It says respondent created majority of the AMR debt due to her insistence to go to the hospital by ambulance, which was deemed unnecessary by EMTs on the scene. And so you're objecting to that language, it sounds like, correct?
Nothing, yes, Your Honor, because actually any couple would divorce a husband if he would not advise the wife to get tested when she faints 3 times in a row in a moment.
Okay, I hear what you're saying. Thank you. Ms. Hoke?
But well, Your Honor, that was your ruling, and you that was reflected in the division of the debt, which gave the bulk of it to Mrs. DeDios and 1,000 to my client, and she, because of the fact that she didn't need to go to the hospital according to the medical professionals, but she insisted on going.
So what I tried to do there was balance kind of those things that Ms. DeDios was talking about, is that, you know, a husband's duty to make sure his wife is okay, and then the patient or Ms. DeDios's duty to not necessarily drive up particular costs. And so that's why I split the ambulance cost in the way that I did. So I'm going to leave 22I as is I think that captures the spirit of what the court was trying to say. We'll look at your paragraph number 6. It says in number 8, request that the Judge Evans' reason for the ruling on the Lexus be stated as clearly as the reason for the denial. 3-month spousal support was denied. So I'm looking at paragraph number 8, and that must be on the divorce decree, where it says no transfer of property is required. Respondent returned the Lexus vehicle to the petition as ordered in the temporary family law order. So what would you like that paragraph to say?
Yes, Your Honor. I just want the reflection of your ruling, Your Honor, where everything there were justified. If they can just include your words in the Lexus ruling, which said that I am not granted the Lexus because my income was low and I am unable to pay for the Lexus. And I have been using it for 8 months.
Okay. Kind of now that the marriage is over, and there's this division of property,
Yes.
in the end, what we're saying is that the Lexus goes to Mr. DeDios, correct?
Yes, Your Honor. I just want the justification, because if there are justifications for every number, I just want it to be parallel with the Lexus, please. It matters to me that your ruling, so that it won't, at least it won't appear to me that it is the thumbprint of the other party. It has to be a reflection of your ruling, which says that I am not granted the Lexus because my expenses is high with the rental and my income is low, and that I have used it for 8 months. Lexus is granted to the other party.
Okay. All right. Thank you. Ms. Hoke?
Well, Your Honor, I think that would not go in the decree, but in the findings. I don't recall that you made all those rulings or findings at the hearing, I think, or the trial. You explained that Mr. had paid the payments, that he had purchased it with separate funds from a separate property vehicle, and she wanted to have it parked in a garage and use it as her residence, basically live in it. And you just indicated that that was impractical. If you have other findings, I don't think we would object to them, but I don't think what she's asking for was ruled at trial.
May I speak, Your Honor? I almost quoted you verbally, Your Honor. You said that my income was low, my expenses were high as per rental, and my income was low, and that I have used it for 8 months, and so you're not granting me the Lexus. It will be on the other party. That's all. There were more, Your Honor, but at least that is the main thing that you were telling me. So if it can just be included there.
Yeah, I mean, I don't disagree with Ms. DeDios, is that was the rationale for the ruling, is that the Lexus payment, Ms. DeDios is not in a position to afford it going forward, and had not been in a position to afford it for the 8 months that she had possession of it. So therefore, it needed to go back to Mr. DeDios. And so I think the divorce decree indicates that there doesn't need to be a transfer because the Lexus has already gone back to Mr. DeDios. And so therefore he has possession of it. And that's showing that he, as the petitioner, has that property. So the findings of fact, I mean, we could have pages and pages and pages of findings of fact that are not necessarily necessary to the final order. Certainly, if the case was to be appealed, the entire record, including everything that was stated on the record, is made part of the record and is part of the order. So I'm going to leave the order as is, because I did enunciate that rationale for the Lexus going to Mr. DeDios, and that's made part of the record. And I don't think it's crucial that it be included within the findings, simply because there's a division of property. Courts have broad discretion in dividing equitably property, and I think that's what the court did here, recognizing an inability to pay in the past and also in the future. So we'll move on from that and not make any changes. Then number 7, it says, I didn't take any of his belongings. All I took was my own things from the Philippines, gifts from different agencies and charitable institutions who provided supplies. And then others had been left in the petitioner's property and other things. So there you say it's your request to change or reword. So I'm not exactly sure. Tell me what you want, what's your proposed language and which paragraph are we looking at to change within those proposed orders?
Well, instead of saying those on the rationale, Your Honor, it will just be because the ruling was very quick and short, and that is okay. You just decided that there will be no more exchanges of belongings because you said I ran away with much. Although that is not, I don't agree with that, but I have to respect your ruling. And also, I was not, excuse me, and also I was not, probably I lacked, excuse me, I lacked explanation on that. So if the justification can just be, excuse me, as short as that, as your ruling, Your Honor. Even though I don't see any harm from my request on the Lexus, but in here again, it is a kind of the opposite. I would request that that just be your plain ruling, just not any of the belongings will be. No, there's no more exchanges of belongings.
So I think what I hear you say, Ms. De Dios, is that you're wanting the order to say that there be no more exchange of personal property between the parties. What everybody has stays with them and there's no additional transfer ordered. Is that accurate?
Yes, that's what you wrote, Your Honor.
Okay. So I think, so taking a look at this, it says under paragraph 8 and paragraph 9, it says the personal property that respondent and petitioner now has control of is given to the petitioner or the respondent respectively as their separate property. So I think that's addressed in both paragraph 8 and 9, where it says basically there's not going to be a transfer, that the property that each party has now remains theirs and there's no transfer. So I think that states that implicitly.
Okay, Your Honor. Are you, Your Honor, I'm not, well, I hope I just want to say, wouldn't you at least consider my request on the Lexus rationale? It's a short sentence to be considered on the Lexus.
Your Honor, I'm just
that
going to
short-
object or ruled on that.
Yeah. What would the short sentence say, Ms. De Dios?
Sorry, Your Honor, can you
What would
pardon
that short sentence regarding the Lexus say?
that I have that I am incapable financially to pay for the Lexus.
Okay. I think what I could do, respondent returned the Lexus vehicle to the petitioner as ordered in the temporary family law order because she was petitioner, pardon me, respondent is financially unable to pay.
Yes, Your Honor.
Ms. Hoke, any concerns if I were to add that language?
No, that's fine. I have one more comment, Lynn.
Okay,
Yep.
go ahead, please. I've added that language to paragraph number 8.
I just wanted to also mention that on amended Exhibit A with regard to the personal property for both the wife and the husband, it indicates that a final division has been completed by the parties. So I think that's consistent with the decree awarding their separate property to them.
Okay,
No
so that
change.
further bolsters that separation. There's no further transfers. Ms. De Dios.
Your Honor, when the time I had lawyers, I think I read something like that on one of the, I heard that, but I mean, I read something like that from the an online record from my lawyers. But when I asked about that, because it was never my side, Your Honor. I never agreed to it because I have my health equipment that is crucial to my health, and I bought it 15 years ago for $1,600. That alkalinizer, water alkalinizer, which Mr. De Dios borrowed in the U.S. ahead of me, Your Honor. So that's the most important thing that I wanted because it's my health equipment. And that is worth $1,600. Aside from the, I can get away with I've given him the grill, the heavy duty grill that's worth $2,000 plus. According to Mr. De Dios, that was a gift to me. I can do away with that with the king rocking chair that was given to me by the agencies. I can do away with that.
So let me ask you, Ms. De Dios, then we talked about all the property, that there's not going to be any further transfers. Are you saying that there should be an additional transfer of one item?
Yes, I put it in my request, Your Honor.
Request that says that.
And everything that I carried, Your Honor, I picked up were my staff from the domestic violence agencies, from the charitable sources like Salvation Army, because they furnished my apartment, Your Honor, because I was able to occupy an apartment before our second reconciliation in May of 2022. So those were the
Pardon me for the interruption. I thought we covered this just previously, where you said that you requested that there be language in the order that says that there be no further transfer, that all the property that is in the respective party's possession remains in the separate party possession of that party. And now you're saying, oh no, there's actually some health equipment that should be transferred. Did the court rule specifically on the health equipment? And was that issue raised at trial? Because I don't think it was, but you can refresh my memory if it was.
Yes, because Your Honor, there were items that were itemized there. I read that from the paper of the opposite party, Your Honor. I remember that very well. That's why from the time that this started last year, I was always consistent about the personal belongings, because even Mr. De Jos told me that.
Let me
hey,
just cut to the chase, if I may. I apologize for interrupting. At trial, was there a specific mention of the $1,600 health equipment that you wanted?
It was not mentioned $1,600, Your Honor, but there was you mentioned about the personal belongings, and it was on my list.
Was it specified as to the health equipment?
Yes, Your Honor, it's called alkalinizer.
Say that again, please.
It's called alkalinizer, Your Honor. It was a special, Your Honor.
And did you testify to that during the trial?
Your Honor, I was not given the chance to discuss that part. I just heard your ruling right away on the ruling. In the same way, I just heard the Korean language. I'm sorry, maybe the interruption or something, but I never really heard those things, the Korean language and the personal belongings. I just heard the personal belongings on the ruling.
Okay. All right. Well, I'm going to stay with my earlier ruling. I don't remember the alkanizer or health equipment. I take notes during the trial, and I typed in a keyword search with health and alkanizer, and then nothing came up. And that was something that if it was raised, I would have noted. And since it wasn't raised, and I'll note also that that you had time to address any of the issues that you wanted to. There was no indication that you were precluded from doing so. So I'm going to sign off on the orders as I've amended them here today, and that'll conclude our hearing. So thank you very much, all of you, for your assistance. Thank you.
Thank you, Your Honor. Appreciate it.
All right, and let me just double check. We've got both parties present. We have Ms. Camarenas present. We have Mr. Connor present. And I just need to refresh my memory. Sometimes this isn't current as far as representation. Mr. Connor, Mr. Roberts is not representing you at this time, correct?
No.
It's just you, and you represent yourselves. Okay.
Yes.
All right, so this is Ms. Camarena's motion for contempt regarding the parenting plan related to the temporary parenting plan that was issued in August of 2022. So I'll hear from you, Ms. Camarena, and then from you, Mr. Connor.
Yes, so the parenting plan, we deviated away from it probably around January of this year. And I guess the stipulations of it was that Stephen would have the boys his regular time, Thursday through at 5 p.m. to Saturday, 5 p.m. at his own apartment. And then the only other thing that was part of that was that he agreed to do those weekly home drug tests. And because he demonstrated, that he had like pretty stable life, employment, had his own place. Those were some of my concerns with giving him more autonomy with the kids at his own environment. And and he demonstrated that. And so I was okay with agreeing to that. And
can I ask a clarifying question on that? So Thursday through Saturday at his apartment, and is that implicit within that there was no supervision while the kids were
Yes,
Thursday,
no
Saturday?
supervision.
Okay, go ahead.
And so that was all good. However, recently in June, Stephen had served me with a restraining order because our youngest had gotten scratched by a cat, and there have been some complaints over this course of the school year, with our youngest being cared for at my aunt's, which I did not, it's not that I dismissed it, it's just I didn't agree that they were serious. For example, our son getting scratched by a cat. He was a toddler at the time. I mean, he's 3.5 now. So like I have my own cat at home and he antagonizes that cat, but luckily our cat just runs away and hides. And this, and our son got scratched by a cat 2 different times, and to feel like that is enough to feel like he's being dismissed because I'm not agreeing that our kid is not being well taken care of, and that I should immediately put him into some other like childcare facility other than my aunt's, and being really coercive about it, and hadn't really directly communicated with me. He had asked to talk and I agreed to, but then we never did. And then he, had just texted me, where is, Nico gonna be? And I responded at my aunt's. And then he, responded like, I already explained why that's not possible. So he's just using this coercive behavior to get me to get our son into a different sort of arrangement. And he knows that I don't have a lot of family support with that because most of my family works. My aunt, unfortunately, she does have that schedule, but most of my family work when I work, so I just don't have that resource. And for him to just imply that that can't happen, which the only other option would be a childcare facility, and he's not offering any support to like look for that. He's not offering any support to help pay for that, which it depends on the facility. But I mean, we're talking about something that could cost up to $2,000 a month out of pocket. And so it's just not a feasible option. But also, I don't believe that my aunt's environment is an inappropriate environment. And so these tactics really just reminded me a lot of the negative, abusive tactics that he would use when we were in a relationship together. And I had thought that, with him being sober and being employed and really showing a lot of stability in his life, like those are all good things. So I just felt very confused as why are we seeing these negative behaviors again? And it really resonated with me that like, okay, for me, I don't know what's going to happen after today, but I just know for myself that I'm not going to be pushed around, and I'm not going to be like coerced into things. Serving me to get a restraining order is just so inappropriate. And quite frankly, it's very absurd. Like that shouldn't have happened. And yeah, so that was my reasoning for wanting to like just go back to the parenting plan as is. I did let him know, like, if he wants to change the parenting plan, he's more than, welcome to pursue that through the court system. That's why we're here, kind of, like that's okay. But that behavior is just not appropriate, and he can't treat me that way.
So can I ask you, the restraining order was served sometime in June. When was your trip to South America? It was sometime in June
Yeah.
also, was it not?
He served me the day before I left. So I don't recall off the top of my head the exact day. I just know he served me the day before I left to my trip.
And when you were on your trip, it was
Mhm.
roughly, it was planned for 7 days, but it ended up being like 12 days, right?
No, I was gone for 10 days.
Okay. And during the 10 days, the children, Nico
Mhm.
and Leo, were with Mr. Connor.
With Stephen and partly with his parents. I know that they had taken some days. But yeah, this happened the day before. And I had to kind of just process all of that while on vacation.
And when did you get back? Because your allegation is that from June 27th to the 29th, that there was unsupervised visit and derogation of the parenting plan. So when did you get back?
I returned the 28th. I had let Stephen know that I wanted to go back. I plan to go back to the parenting plan as is because of the recent situation with trying to get a restraining order over me. And then, the coercive behavior with trying to get me to get our youngest in some sort of childcare where I'd be responsible for paying a very large amount of money that I do not have. And part of in my declaration, I had mentioned one of the things I believe of why it's happening is because this past year, Stephen has paid child support because the state has enforced it, and they're garnishing it from his check. But prior to that, he went 2.5 years of willfully not financially supporting his kids. He helped out for like 6 months. He was giving me $250. I asked for more because that's not enough for 2 children, and this was during the pandemic. The daycares were getting shut down for like 1 week to 2 weeks at a time, depending on the time frame. if there was a COVID case. So I missed a lot of work and I asked for more money and he chose to just stop giving me anything. And so I went 2.5 years
How does
without
that,
it.
without the child support, not receiving child support for 2.5 years, how does that relate to your motion for contempt?
Well, part of that is just like the reasoning of like the coercive tactics. I'm just ranting right now. But the
Okay.
motion for contempt, I wish would like the parenting plan followed as is, because if Stephen is engaging in these behaviors, one thing like I had to like reflect on this while on my trip is that, yeah, he was very psychologically abusive. He was very emotionally abusive. And these manipulative behaviors, that tells me this is someone who doesn't have the self-regulating and healthy coping skills that he should have to model for our kids. Multiple times when he has picked up the kids or I've gone to pick the kids up, he has been very frazzled, high strung, stressed. He's complained that because it took more than 5 minutes to get the kids out the door, that was too much. And I've just let those things go. But because he's also having these very big reactions to like filing a restraining order, like that doesn't tell me someone who is in a very mentally healthy, stable.
Can I ask you the supervised visits previously, was that related to substance use?
Yeah, substance use.
Okay,
Because
so you kind of pivoted from substance use to controlling behaviors, and that was your rationale for terminating
Yes.
the agreement.
yeah.
Okay. I think I have a good understanding of where you're coming from. Thank you. Mr. Connor, your position?
I guess it's hard for me to sit here and be accused of bad behaviors when I'm just trying to advocate for the safety and well-being of my children. None of this really started to escalate until the repeated cat scratches and Leo being forced to change schools. That was hard for him. I know he switched from being in preschool to kindergarten with a new group of people. And then so he was in kindergarten and then being forced to move again for first grade next year. I mean, a lot of those things lumped together was why I filed for the restraining order. I felt like their care and their needs weren't being put at the forefront, which is, why I entered recovery in the first place, was to have the opportunity to be a good dad, and really taking those steps seriously. And that's why all of this action has been brought before you, is because I don't feel like my kids, I've offered to take them when she needs to go to work and she just refuses. She forces them into an environment I've reported to her concerns me. Many times I've reported concerns me. I've had to call CPS over it and nothing ever gets better. And I'm accused of being manipulative. But I followed all of our agreements until she came back and told me I needed to go back because my kids love it at my apartment. We're free there. It's just the three of us. My boys love being there. They're very safe. A lot of this has just felt like an attempt to control me in my life and my ability to grow and move on from the past. As you can hear, we sit and talk a lot about the past, and I'm just trying to move on. Have my kids have happy, healthy lives where they're safe and loved all the time.
All right, thank you. So the motion for contempt brought by Ms. Camarena is focused on the August 2022 temporary order where it says the father's residential time is Thursday from 5 to Saturday at 5 and has to be supervised by the paternal grandparents. So it sounds like Mr. Connor was making progress as far as like substance use concerns. Ms. Camarena recognized that and felt like the children did not need to be supervised. Therefore, in January, they made an agreement, which is not uncommon in parenting plan cases. Not uncommon that people take action in derogation of the order, and that was continued for a number of months, possibly up to 6 months. Then Ms. Camarena took a trip to South America. During that time, the children were with the father. There was no requirement that there be supervision during that time frame. And then shortly, I think you said it was just shortly before you left from the trip, then you got the restraining order motion filed from Mr. Connor related to the animal scratches and the care of the children by the aunt. And so then the shift of focus, the focus shifted from a focus of substance use to control issues and the like. And therefore, Ms. Camarena alleges that on June 27th through the 29th, when she returned from Peru on June 28th, that the parties were, Mr. Connor was violating the parenting plan because she had revoked that agreement. I'm denying the contempt. I think under those circumstances, there was great trust in the parties and that the supervision was not required. And it seems that there was a bit of retaliation from both, if you will. Mr. Connor had concerns about the cat scratches, which seems reasonable. may not have been the best vehicle to express that dissatisfaction. And then I think Ms. Camarena took offense to that and said, well, fine, we're just going back to the parenting plan. So it's denied. So I'm denying that. The parenting plan from August of 2022 still remains. If the parties feel that that's appropriate to change based on track record of sobriety and the like, the parties are certainly welcome to bring a motion to make that change. So I'm denying the motion.
Okay.
Thanks. That'll conclude the matter.
Your Honor, this is Beth Fellows. I am a GAL that was appointed on August 7th. I just wanted to let the court know that I am present and that I will be looking into these issues as well.
Thank you, Ms. Fellows. I appreciate that. All right, that'll conclude there. And thank you.
Okay, thank you.
We should have Ms. Wade representing Mr. Gallagher. Ms. Wade, are you there?
Ms. Powers and Mr. Gallagher is here present in my office.
Sorry for the reversion.
No problem.
Okay, and then, so Ms. Powers is present. Ms. Moore, you're present. Can you-
Good morning, Your Honor. I apologize for being a little late this morning. I was in the wrong courtroom.
If you had not apologized, I would have not known that you were tardy. And then Ms. Schaefer is here also.
Yes, Your Honor.
Very good. Thank you, Ms. Schaefer. And then Ms. Moore, is your client on the line?
She is, Your Honor.
Okay, great. Thank you. So we're on today for a presentation from the adequate cause hearing for modification on the parenting plan, and also then to take a look at the report from the family court investigator, Ms. Schaefer. So let's maybe, if we could please start with the adequate cause, the presentation on that. So let me just pull that, get that for me, and I'll hear, it looks like Ms. Powers drafted the proposed order, and I'll ask Ms. Moore, do you have any objections to the proposed order?
I do have one objection, Your Honor. I don't believe the court stated that Ms. Stanley did not file a response to the adequate cause petition. We did in fact file a response. Other than that, I don't see anything, have any issues with what Ms. Powers has drafted.
Okay, where is that that concern related to the filing in the proposed order?
I may have misread, Your Honor.
Okay, because I'm looking over that order. It's a fairly short order, and I don't see any reference to a non-filing reference.
My apologies. I obviously misconstrued something that I read in that. So we don't have any issues with the order as proposed.
Okay, great. Thank you. So I've signed off on that, on the adequate cause order. That's signed. And then we're also here on, looks like Ms. Schaefer filed her report. This is dated the 19th of August. And so it's fairly fresh off the presses, if you will. And she makes some recommendations. I don't know if we take any action on those at this point, since it's fairly fresh, or if the parties wanted to have an opportunity to chime in with either agreement or disagreement with those recommendations. I'll hear from the parties.
Your Honor, I would ask that the court make a temporary parenting plan today. The kids are supposed to start school next week, and we need some direction on where the kids are starting. We have reviewed the court investigator's report, and we are in agreement with her recommendations and would like to move forward.
Okay, and I think the parties did address that. I mean, I think there was previously that there were some concerns related to that. But so thanks for refreshing my memory about the school issue. Ms. Moore.
Thank you, Your Honor. We would like an opportunity just to respond. I wonder if the court has had an opportunity to read Ms. Stanley's reply declaration that we filed yesterday.
Yep, I read it.
Okay, thank you, Your Honor. We do have a couple of concerns about the FCI's report and her recommendation. So if the court is willing to hear that, we'd like to speak on those issues.
Yeah, that's fine. We can go ahead. That, you know, in short, I hear the recommendations from Ms. Schaefer, and this will kind of just serve as a lead off or a springboard for respective comments. There's a recommendation that the children attends the school, the 2024-2025 school year with father. The mother would have the first, third, and fifth holiday or weekends, pardon me. Holidays wouldn't change from the prior order. That there be a victim of a domestic violence class taken by the mother. Counseling continue for both children. That there be no male adult friends or significant others around the children for a period of 12 months. And details of court, don't share that with the kids. I put down especially dad. And then drug testing provisions remain for the father. So that's kind of the recommendations. I'll hear from Ms. Moore.
Thank you, Your Honor. We're asking, first of all, that the court make make a temporary plan. We don't think it's appropriate at this time, as the court has already noted. We're sort of early days, so we're not at the point where we would be completely modifying the parenting plan and changing it on a permanent basis. We believe it's important for the children to continue counseling, so we agree with that, especially given Mr. Gallagher's actions in exposing the children to the finest details of the case. We have no objection at all to the children being in Kelso for the fall semester. Ms. Stanley's concern is she doesn't want the children to feel that they're going to be in Kelso forever and that they don't have the option to come back to Cle Elum. Ordinarily, I would not ask the court to do this, but I think the children need to be informed that they can go back to Cle Elum if they want to, because they've already been involved in the case. They've already been asked to make choices. We just want them to know that they're not stuck with a choice and that it doesn't reflect at all on their feelings for either parent. We think both parents love the children and the children love both of their parents. So we don't think that's an issue at all. We do have some concern about the suggestion that Ms. Stanley not have any male friends, adult male friends around while the children are with her. This seems to me to be an unwarranted restriction, and I believe we would need more information in order for the court to say this is needed and how, and that it's narrowly tailored to achieve a specific interest. I don't see that here. I would also mention, and I know you saw this in the declaration, Mr. Gallagher's wife has 2 teenage boys, one of whom lives in the home. If Ireland is having issues with adult males, it's not going to be specific to Cle Elum. There's not something special about Cle Elum. If she's uncomfortable around men, that's going to be something that's universal for her. And I tell the court, I'm an adult survivor of childhood sexual abuse. And so if you have discomfort, it's going to be with the entire population. It's not just going to be in one specific place based on my experience. If the court is in any way considering this, we would ask that no other males be allowed around the kids when they're at dad's too. We're also asking the court to address the issue of attorney's fees. I know the court has reserved on that thus far. At this point, we have expended over 50 hours on Ms. Stanley's behalf. As the worksheets that Mr. Gallagher submitted show, he makes significantly more than Ms. Stanley, and this case has put her in financial hardship. I would like the court to also be aware, although it's not directly pertinent to making that decision, he's only been paying $1,000 a month in child support. Based just on the presumptive schedule, he would be paying over $2,000 a month. And if I had represented Ms. Stanley when this came up, I would have asked the court to exceed the presumptive amount, because this leads to a disparity between the standard of living for the children in both homes. So we would ask the court to award attorney fees to Ms. Stanley, and we're happy to provide any documentation that the court would like to see for that. Thank you, Your Honor.
Very good. Thank you, Ms. Moore. Ms. Powers?
Thank you, Your Honor. Just briefly in response, I want to make sure that the court recognizes, this was highlighted in the court investigators report. When we were in front of you last 2 weeks ago, the court said we were reverting back to the original parenting plan, which would have put the kids with mom for the last 2 weeks. The court also put in a provision that mom would have no romantic interests around the children during her time with the kids. Despite your order, Ms. Stanley only chose to take the kids for 1 weekend. This was not communicated to us ahead of time. We didn't become aware that that was her plan until Mr. Gallagher had dropped the kids off for visitation. During that 1 weekend with the kids, she chose to take them boating with 2 single men. Ireland came back from the visit very upset. There's been a lot of allegations from Ms. Stanley that my client is inappropriately talking to the kids. He was not questioning the kids about this visit. Ireland came home upset and on her own told Mr. Gallagher what had occurred, that they had been on this boating trip. We believe that boating trip violated the court's order. We don't understand why Miss Stanley didn't take those 2 weeks, but we are really concerned here that she seems to prioritize men in her life over these kids. At this point, we are asking the court to adopt the court investigator's report. I also want to touch briefly, Ms. Moore indicated that the kids have been put in a position where they think they get to make a choice and have been asked to make choices. That is not the case. The adults in this situation have brought this before the court to make a decision. It is my understanding that Mr. Gallagher has not put the kids in a position where they think they have the ability to decide where they are and what they do. Mr. Gallagher has reviewed the court investigator report. He agrees that nobody should be talking to the children, and he has been doing the best he can to juggle the fact that we've got a 14-year-old here. I think everybody's ignored that. Ireland is 14 years old, and as a 14-year-old, she is taking in observations on her own of the world around her, and she's drawing conclusions. And she has just been the victim of a crime where her privacy has been violated horribly, and she is working on processing that. Some of the things she's saying could just be because she's observed this and is trying to put all these pieces together. I don't think it's fair to allege that anything Ireland says means that Mr. Gallagher has talked to her inappropriately. So I'd ask the court to take that into consideration. I'd also point out to the court that we have asked for a restriction for males around Miss Stanley and the kids because the history has shown that the men Miss Stanley has had around the kids has abused the children. We've got the situation with Ireland, who's been a clear victim, but the court investigator report and also our declarations indicate that Sawyer has also been a victim of these men. This is not a restriction that needs to be applied to Mr. Gallagher because there's been no evidence to suggest Mr. Gallagher has had men around the children that are harmful to them. Ms. Stanley, in her reply declaration that was just filed this week, makes some pretty low blows about some family drama that happened historically in the Gallagher household. We have not had an opportunity to respond to that, but I would say that we don't even need to respond to it. It's not relevant to the issues before the court. What we have before the court is evidence that the kids were injured because of Miss Stanley's choices in males. We have the court making an order 2 weeks ago that she not have romantic interests around the kids. We have her exercising only 2 out of 14 days that she could have exercised. And in those 2 days, she brings them around 2 single males on a boat where people would presumptively be wearing swimsuits when we've got Ireland just healing from violation of her privacy. No wonder Ireland was upset after this occurred. The stepbrothers have been in the picture for several years. There have been no allegations of anything inappropriate. Mr. Gallagher's home has been a safe place for the children. We ask the court not to impose any restrictions around these stepchildren. And we do ask the court to enter temporary orders, adopt the investigator's report, and then also briefly in terms of child support and attorney fees, Ms. Stanley has not filed a financial declaration. She has not filed any pay stubs or income tax returns. Yes, Mr. Gallagher makes a significant amount of money. We have no information about the income in Ms. Stanley's household. It is not appropriate for the court to order attorney fees just based on the fact that one client makes a lot of money when we have no information about the financial status of the other parent. Additionally, we are asking the court to stop the father's child support obligation going forward if the kids remain with Mr. Gallagher. We are not asking the court to establish a child support obligation against Miss Stanley. Mr. Gallagher does have sufficient in his household to support the children. And lastly, we're asking the court to appoint a GAL, and Mr. Gallagher is willing to cover 100% of the cost of that GAL. Thank you.
Your Honor, may I respond just briefly, please?
Yeah, that's fine.
Thank you. I appreciate the irony in Mr. Gallagher continuing to talk about Miss Stanley's choices in men, especially since he was one of them. And it should not be discounted that during the divorce, he had supervised visits because he himself was harmful to the children. And the people that were on the boat were just friends. They weren't romantic interest. It seems that Mr. Gallagher is just trying to drum up more things against my client. There isn't an allegation that he's talking to the children about the case. That's actually a fact. And the family court investigator noted that in her report and also made it part of her recommendations. So I don't think it's possible for us to really believe as rational, reasonable people that this occurred and the children haven't been influenced at all. And I wanted to be clear, I apologize to Ms. Powers because there was apparently a miscommunication on my part. Ms. Stanley was concerned with the way that all of this occurred this summer with Mr. Gallagher's actions. She didn't want to upset the children by suddenly changing the visitation. And so what she had suggested was, let me take them for the weekend. We'll just have a visit. Then they can go back to dad's until we've had a chance to go back to court and see what the judge says. So for her, that was about doing what's in the children's best interest, not because she's out gallivanting with men. And I quite frankly object to that characterization. It's inappropriate. So we're asking that we don't have a problem with the children being enrolled in Kelso. We think that's appropriate. We want to be able to revisit it for the spring semester and see where the children are going. And we're just asking that restriction for all male friends either apply to both parents or neither. Thank you, Your Honor.
Thanks, Ms. Moore. Ms. Schaefer, do you have any comments you'd like to highlight?
Yes, Your Honor. Unfortunately, I didn't receive a copy of Mom's response, so I'm just going to try to address some of the things Ms. Moore brought up. I don't think it's a good idea to reevaluate the children in the middle of the school year. I think they should be able to complete the entire school year. I think it would be in their best interest to be able to continue the whole entire time instead of having to transition maybe back to the school if that's their choice. I do believe that they should have a choice if they don't like the school. My second concern is with the meals for mom. I would like for it to specifically be for mom. I do feel that mom made a couple poor choices in the last couple of weeks with allowing the first gentleman, Travis, to stay longer than he should have. And then when she does get them back, it's more about having fun with the kids. And she did put Ireland in a unfortunate circumstance on that boat and made her uncomfortable. I don't think her forethought was about Ireland and what she has gone through and how to help her heal. And so that's my concern with the other male friends being around mom.
Thank you, Ms. Schaefer. Okay, so related to the temporary parenting plan going forward and the need for some direction with the school year starting here soon. So kind of the basis of this, let me just start with the adult male issue that seemed to gather quite a bit of airtime. The court did order on August 6th that Ms. Stanley not expose the children to any of her romantic interests until the court gives further orders, which would be today. So, language is squishy. Language is sometimes imprecise. When you say romantic interest, that may very well be hard to quantify and measure. What we do know is in the past, Ms. Stanley has chosen two men whose the relationships with each of them has resulted in either a restraining order, a prohibition order, or a no contact order, preventing them from having contact with either her or the children or both. So I'll just make mention to the parties that are in the courtroom here today that even really quite hushed whispers, there's something about the human brain when they hear the human voice speaking. I hear it and it distracts me. So please don't whisper. Mr. Vorse, please don't whisper. So I was just saying that the human mind is attuned to hear human voices, and the acoustics are good in this room in a way, kind of bad in a way, in another way. But when people are whispering, I hear you and it's distracting. So I appreciate if you need to converse, please go outside. So with regard to those two companions, there were resulted in no contact orders, which subsequent to that, there was an opportunity to go boating. And in context, I can see where Ms. Stanley said that might be fun for the kids. And I can see where that may be very tone deaf to the situation of a young lady whose privacy has been obliterated. So it's, there's concerns there. So while Ms. Stanley indicates in her reply declaration that they're not romantic interests, friendships begin in all kinds of different ways. So I think the prohibition of having any adult male around the children is appropriate for a period of 1 year. And it applies simply and solely to Ms. Stanley. And the issue with the stepbrothers, there's been no issues raised related to the stepbrothers. And again, I think there's a distinction there category-wise. The adult men that were brought into the home were adult men of significant older age. where the other stepbrothers are much closer in age to her, and our minors are just passed through the minor phase. So with regard to the school, I'm going to order that the children attend locally in the Cowlitz County, which I think is the Kelso School District, for the school year 2024 through 2025. And I think that's important to have that continuity, that it not be addressed. It'll be for the full school year. Mother will have the first and third and fifth weekends as presented and recommended by the family court investigator. I do think it's important that there be a little more education, maybe some of that tone deafness that I spoke of with education, and maybe exposure to different ideas and playing with those ideas and working through some of those issues would be of assistance to Ms. Stanley. So I'm going to order that she sign up and complete a victim of domestic violence class, because I think that she has been victimized in some shape and form. Counseling, it sounds like both parties are agreed that the children will continue to do that, and I appreciate everybody supporting them. I think it goes without saying that both parties are prohibited from discussing adult issues, meaning court issues with the children. I recognize that tends to be a very hard thing to do, especially when you have a 14-year-old. 14-year-olds are pretty keen and perceptive, and it's hard not to talk about those things. What happens when you do talk about those things with children? Children take ownership of those items, and that they feel that they have some control over the situation. And when things don't go that way, they want to please both parents desperately. Desperately, they want to please both parents. And if when they do one thing or another, they take upon themselves unneeded stress and anxiety and responsibility. So please, 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 just let them know the judge says I can't talk to you about it. Put the blame on me. So the issue of the drug testing, those provisions still remain. That's fine. Attorney fees, I'm going to reserve on that, as I indicated before. The reason we're here due to decisions made by Ms. Stanley. And that led to a motion for adequate cause and a modification or granting of an adequate cause order and a change in the parenting plan. In addition to that, the financial waters are not terribly clear, at least in my mind. Once the children are returned to the father, then his child support obligation would cease at that point. And I will grant the motion for appointment of a guardian ad litem with Mr. Gallagher covering the cost 100% for that appointment. We need to talk about who that person would be. We have 3 individuals that are primed up on the list. And if we want to proceed in that fashion, I could have the clerk say those 3 names, and then you could exercise a strike if you so choose.
Yes, please.
Your Honor, we'd like an opportunity, because I'm not in Cowlitz County normally, I'd like an opportunity to be able to find out some information about the GALs, if the court would allow that.
Sure. And let me just ask kind of your approach on that. Generally in court, I would present 3 individuals that would be next on the list. I guess we could present those 3 names and then kind of reserve that in time and space, and then come back in a week or so. And if there's an exercise, any strikes based on those 3 names. Are you okay with that, Ms. Moore?
Yes, Your Honor, I'm fine with that. Normally, how we handle it when the parties are represented in the other counties where I appear is the attorneys just talk and come to agreement on a GAL, and I'm sure that Ms. Powers and I can do that.
Your Honor, I'd ask that you give the next 3 names and I be able to put my strike on the record, and then Ms. Moore can report either to the court or email to the clerk and I within the next 3 days if she's striking one of the names.
That might be just as efficient rather than having to come back. That I'll present the names. That way Ms. Moore knows who those names are, and she has the opportunity to do some research and find out a bit more about each of those individuals. I'm fine with Ms. Powers exercising a strike today, and Ms. Moore can exercise a strike sometime prior to next Wednesday. I'll give you a week to look at it, because that 3 days is a pretty quick turnaround time if you're not from the area. So,
and also I'm out of the office for a few days too.
All right. So by next Wednesday. So let's hear those 3 names, and we'll go from there.
We have Karen Lawrence, Heather Call, Beth Fellows.
Okay.
I will strike Beth Fellows.
Okay, Ms. Fellows is stricken. So then the 2 remaining are Karen Lawrence and Heather Call. Heather's Call spells her last name Kahl.
Thank you.
Yes. All right. So what I'd ask the party, so this doesn't get lost in the shuffle, the attorneys are going to communicate with each other as to whether Ms. Moore will have a strike. If there is no strike, then the next person on the list, which would be Karen Lawrence, would serve. If Ms. Moore strikes say she strikes Ms. Lawrence, then it'd be Ms. Call. If she strikes Ms. Call, then it would be Ms. Lawrence as the appointed person as the guardian ad litem. So if the parties, once you've communicated with each other, if you could just forward a copy to myself with just a little reminder, a tickler file, say, Judge, this is the guardian ad litem. Please either sign off on this proposed guardian ad litem order, or that would be my preference. If the parties, once you've come to who that person is going to be, if you could just forward the proposed guardian order appointing guardian to me, and then I can sign off on it.
Your Honor, could I propose a different solution?
Sure.
Could we just set this for presentation next Wednesday? I'll have the GAL order already, except I won't have the GAL name written in. And then when we appear for presentation, the court can write in whichever name. Because we still need to enter the temporary parenting plan and other orders.
There's more.
I'm sorry, I didn't mean to talk over anybody. I am not available next week. I'm just looking, today's the 21st. I'm not available through Wednesday of next week. And
Could we put it on your presentation docket Friday the 30th at 8:45?
See, let me check my calendar.
I can do that, Your Honor.
Yep, that works. We'll set it for presentation August 30th at 8:45 in the morning, and parties can appear via Zoom, and any proposed orders, you can just forward those to me via email.
Thank you.
Thank you, Your Honor.
Cause number. Okay, thank you much. We'll see everybody on August 30th, 8:45.
Thank you.
Great. And Maggie Sills, are you on the line? All right, Ms. Sills, if you're on the line, if you'll please state your name and make sure you're unmuted. Just looking through the participant list. I do note that I'll recognize that Ms. Height is present, the guardian ad litem.
Yes, Your Honor.
Anybody have any communication with Ms. Sills today, either the courtroom clerk or Mr. Sills or Ms. Height, about any difficulties about appearing today?
I have not, Your Honor. She has not been participating to this point.
Okay. All right. Thank you. Let me just double check with Mr. Sills. Mr. Sills, let me just pull up some documents here. I have proposed orders that it looks like that you've prepared and you've submitted to the court. So I have them here. What I wanted to check with you is these documents were served on Ms. Sills on August 3rd, according to the affidavit or declaration of service. Does that sound right, Mr. Sills?
Correct.
So August 3rd until August 21st is less than 20 days. Would you agree with that?
Correct.
So prior to a hearing, there needs to be service of documents at least 20 days prior, according to local rule 88. So that's my first concern. And then my second concern is that it looks like you filed a notice of intended relocation, and that was served on, Ms. Sills on August 3rd. And she has, according to that same paperwork, she has 30 days to respond, which would be sometime around September 3rd. So that's my second concern as far as proceeding today. So do you want to, can you address that? Because what I'm thinking is that there's just, it's timely, it's premature according to the local rules for me to sign off on these orders. And I recognize that that's probably pretty frustrating for you because Ms. Sills has not been participating for a long period of time, including no visitation with the child since I think March it was.
Correct.
So I think we need to, according to the rules, I think we just need to wait for that time frame to pass. So what I'm proposing is since she's been served with that intended notice of relocation on the 3rd of August, that we come back on September 4th, which would be the 30 plus days. And if she's going to object, she'll file something and we can address it then. Otherwise, if we come back on the 4th, then there would definitely be the 20 days for service. And we would note that she wasn't here today. So that's my proposal. Do you have any concerns related to that proposal, Mr. Sills?
Would we be able to just, I guess the 28th wouldn't be the 30 days, correct?
Yeah, right.
I know that there's also, she's got to be served with that 60 days prior, so.
Yes, so the intended relocation that you filed, I think on it, it says. So this is giving directive language to Ms. Sills. It says, if you do not agree with the planned move or with any of the changes requested to the parenting order, you must file and serve an objection within 30 days of receiving the notice. So that's why I'm thinking the 30 days and set it over to the 4th. So I think that, yeah, it's frustrating.
Well, it's just, the documents keep on getting returned since nobody has any form of way of getting in contact with her. If she was handling this how she should be handling it, I feel like she would have updated her address or given me some form of contact so I could actually serve her with these documents.
Right.
In which case she would have had more than enough time to, file an objection. So
Want to check with Ann Height on the parenting plan. She's good with that.
It's frustrating because it creates an inconvenience, obviously, and it's interfering with my ability to successfully complete the apprenticeship program that I'm in. I've already lost a lot of hours, so at this point I'm working 11-hour shifts, 5 to 6 days a week, so I can make up for those hours to successfully complete the program within a year. I understand that the time frames are not in accordance, but I also feel that it's since she's not cooperating,
And she started it.
and she
So
initially
aware that you can't have somebody prompting you what to say. That would be inappropriate. Because like if you're in the courtroom and somebody's telling you what to say, I would shut that down. So I'm going to shut that down here too, please.
yes, Your Honor.
So, I hear what you're saying, Mr. Sills. It's really frustrating. It's causing you to work extra hours because you have to take time off from your program that you're wanting to get done.
So it takes time.
So I'm speaking. Don't interrupt me, please.
Yep.
So I hear what you're saying. I hear what you're saying. And I know that the rules, if you don't follow the rules, that's a really easy reversal when somebody comes back and says, hey, look, they didn't follow the rules. They didn't wait the appropriate time. That's a quick and easy reversal. So to make sure that everything's done appropriately, everybody follows the rules, that the order stands on solid grounds, we'll set this matter over to September 4th at 9 o'clock. We'll keep hold of your proposed orders, and then we will address the matter at that time. And I appreciate your patience and I apologize for your frustration.
Your Honor.
Yes, Ms. Hyde.
Yep.
Are you anticipating on the relocation piece any input from me on that? I just would appreciate some direction. I typically, if this is part of a case, I would address some of that. I just don't know if that's necessary or appropriate at this time.
My sense is that according to the pleadings, Ms. Sills has not been engaged with the child since March. I think that sends a pretty clear message that obviates the need for you chiming in.
Okay. Thank you, Your Honor. I appreciate that direction.
Thanks. Mr. Sills, we'll see you on September 4th, and thanks again.
Thank you.
First, I'll ask if Courtney Brummett, if you're on the line.
Yes, I'm here.
And is your last name pronounced Brummett?
It's Brummett.
Brummett, thank you. Thanks for the correction. All right, and then Matthew Bradley, are you on the line? So let me look through the participant list. Matthew, not seeing a Matthew. Oh, there's an M. Bradley. So Mr. Bradley is Ms. Brummett what's the correct pronunciation of the last name?
It's Bradley, and he should be in here.
Yeah, thank you. All right, so Ms. Brummett is here. Is it Brummett? Tell it to me one more time.
It's Brummett.
Brummett. Okay, so it's the long sound. Okay, so Ms. Brummett is here, and it looks like Mr. Bradley is here also. Mr. Bradley, you're in the Zoom call, but you're muted and your camera is off. So I'd ask you to turn on your camera and turn on your volume so we can hear you.
I know he was in here because he was just texting me, so I know that he.
Yeah, he's in the Zoom call. I mean, there's an M. Bradley that's listed as a participant. Maybe what we could do, and I do note that Mr. Lawrence is here also, the guardian ad litem. Maybe what we could do, if anybody has contact information with Mr. Bradley, let him know we're ready to call the case. We've called the case, and I'm going to address one other matter, then come back to this matter, and hopefully he'll be ready to go.
Okay, perfect. Can I leave the Zoom and then call him real quick?
Sure, that's fine.
Perfect, thank you.
Ms. Schaefer is a family court investigator. She's on the line. Angel Mosquita, I see that you're on the line. Can you hear me?
Yeah, I can hear you.
Okay, welcome to you. And then Michael Miller, are you on the line today?
I didn't see him in here.
I haven't seen him yet either, Your Honor.
Okay, I'm not seeing him. Michael Miller, if you're on the line, please make sure you're unmuted and state your name. It looks like he's not in the courtroom. He's not coming forward. If he has come forward, and it looks like he's not on the Zoom call today. So we're here today. It looks like there were some recommendations given by the family court investigator on the 7th of August. Largely, it sounds like the parties agreed with that, but they wanted to kind of work out some finer details. And if they disagreed, then they would file a proposed parenting plan. According to my court review of the court file, nobody's filed any updated parenting plans. So as a result, I'm assuming that the recommendations made by Ms. Schaefer carry sway. So I'll hear from Ms. Mosquita.
So I did talk to him and I did let him know that with my work schedule I can do visits the Thursdays that we've been normally doing them from 4:30 to 6:30, and Friday I can do them that day. And then some Saturdays I'm available for longer visits as well.
Okay, and that would be this up to 6 hours on Saturday, and then the
Yes.
3 hours on the weekday.
Yeah, and then I told him on Saturdays if our child wants to go back home because of how long the visit is, if he just like gets tired, I would bring him home.
Okay, all right. Ms. Schaefer, have you had any contact with Mr. Miller?
No, Your Honor, I haven't. I think we were just deciding what days, as Ms. Amsakita's schedule kind of fluctuates, and there just wasn't clarity in my recommendations for that.
Okay, so Ms. Mosquita, it sounds like Thursday, Fridays during the week, those are the best days.
Yes.
Okay. So what we have, the recommendation is that the custodial parent would be Mr. Miller, with Ms. Mosquita's visitations occurring unsupervised in the community on Thursdays and Fridays for up to 2 to 3 hours, and on Saturday up to 6 hours. And it's okay to bring the youngest child to the visit. And if there are any visits outside of the Kelso Longview area, there needs to be approval from Mr. Miller 24 hours prior in advance. Mr. Chaddock would not be present or in the vicinity of the visit under any circumstances. And then joint decision-making on school and health, non-emergent health issues, and that no significant other or romantic interest introduction to the children until there's been 6 months of consecutive dating, and that both parties are prohibited from disparaging the other party or their significant other. So those are the recommendations. So any comments on those, Ms. Mosquita?
Just with the medical thing, I had to re-add myself to my children's medical because I was removed by Mr. Miller's grandma. So I had to jump through hoops to be re-added back to all my children's medical stuff at the doctor's office.
Okay, so you're back on there?
Yes, and I made a note that only me and Dad should be involved with medical stuff.
Okay. And you made that note with the provider?
Yes.
Okay. All right. So let me just go back here a little bit. Ms. Schaefer, you filed your report back early part of June, was it not?
I believe so, yes.
Okay. We need to memorialize that ruling that the court is adopting the family court investigator's recommendations. And generally that's done by one of the parties, and then it's drafted and then sent to the other party, and then we copy sent to the court. And then we have set a date for everybody to have reviewed it and then sign off on it. Ms. Mosquita, tell me about your comfort level in preparing such an order.
I can try. Would it just be like filling out a parenting plan with what we talked about?
Yes.
Okay.
So let's do that then. let's look at a date. Today's the 21st. Let's plan on coming back on September 4th at 9 o'clock in the morning. So Ms. Amaskita, you'll prepare that parenting plan order and based on the family court investigator's recommendations and supply that to Mr. Miller and then supply a copy to the court also. And send
Okay, and it,
and send
sorry.
one to, and send one to Ms. Schaefer also.
Okay.
Ms. Schaefer, do you have any comment?
No, Your Honor.
Okay. All right. So we'll look forward to seeing that that proposed order, and we'll be back here on the 4th at 9 o'clock in the morning.
Okay, thank you.
All right. Thank you.
Thank you.
We have Mr. Wood coming forward. He'll be taking a seat, and then I'll ask if Ms. McAdams is on the line.
I am.
Okay, great. I see you and I can hear you. Thank you. All right. So we're here today for a motion brought by Ms. McAdams for an extension of a restraining order that was entered on July 14th and then July 28th of 2023, which resulted from a default order that was entered in May of 2023 that restricts Mr. Wood from coming within 500 feet, not disturbing the peace and not hurting or threatening Ms. McAdams and the children or child. So that's where we're at. So I've read the pleadings by the parties. I'll hear first from Ms. McAdams and then I'll hear from Mr. Wood.
Yeah, I'm just wanting to extend it another year if possible. I don't know if anything will happen as for, the threats and stuff that have been made in the past. I still don't feel comfortable with him living right down the street from me, literally.
What do you think the distance is? You kind of ventured a guess. Have you measured it out or?
I mean, I haven't measured it out, but literally he's like 5-6 houses down the street from me.
Okay.
So I just, with the threats that he had made, and being a domestic violence survivor myself, it just kind of worries me. So I want to get another year of the restraining order to protect myself and also my son. And we'll go from there. I'm hoping he'll move on and it won't have to go another year after this one.
Since the order has been entered back in July of 2023, have there been any violations or alleged violations of the order?
He was doing visitations, and then I was told that because the restraining order doesn't allow it, or I don't remember exactly what was said, but he did drop my son off in the driveway, and I talked to an officer. They said that is a violation of it. So if he did it again, then he could be arrested. So he did do that at a short period of time until the officers had talked to him. But since then, no, nothing has been violated.
Okay, so you said a drop off occurred in the driveway of the child?
Yes.
Okay. Let me ask you just a clarifying question, just make sure I'm reading the file correctly.
Mm-hmm.
It's like those two orders were entered. There was an initial order on the 14th, and then there was an amendment on the 28th of July that included a distance restriction that was omitted from the July 14th order. And my question is, those orders were entered as a result of a default order that was entered in May, meaning you'd asked for these things, you'd served Mr. Wood, and Mr. Wood didn't respond to anything, and so you won, right?
Yes.
Okay. And in leading up to that, in your petition or the paperwork that led up to that default order in May, did you make any reference to or allegations to threats or concerns for your safety or the safety of the child?
Did I make threats?
No, did you make mention or reference of any threats or concerns for your safety in your prior to the default order being entered?
Prior to it, no.
Okay.
Because he made threats when he was out of state before he got back to Washington State. He had made some threats because he says he was drunk, but it still doesn't make it okay to make the threats that he made. So when he got back, I had him served. Well, come to find out, the original restraining order there was things that weren't put on it. So they told me to do a motion to change that. So that's where I changed the original restraining order. And then that went up until July 28th or whatever of this year. So then I wanted to extend it out another year, just for my safety and just for the well-being. I just feel that another year to give him another year to move on and not bother me or anything like that, I think would be best.
Okay. All right. Thank you. All right, Mr. Wood.
It's been, I mean, what she's saying is true. I went to Alaska. I made some vulgar threats when I was drinking because she was cheating on me and letting me know that she was going to serve me with divorce papers or the final divorce papers. But that 3-month cool off period, she was telling me not to respond. I didn't need to because I just needed to quit drinking and she wasn't going to follow through with the divorce. And when I called the courthouse, they said, yeah, there is a 3-month kind of a cool off period. And if neither parties respond on it, then it dissolves itself. So I believed her. I believed what she was saying. So I didn't respond to anything. And I came back from Alaska the first time. I was in Juneau and I noticed she was going next door and it was only when a blue truck showed up. And she'd stay over there from 6 o'clock till midnight, 1 o'clock in the morning. And when I asked her about it, she said it was none of my business. She's not doing anything. When I had talked to her daughter said that she was kind of fraternizing with another guy named Brandon over there. And then I was forced to go do another job in Alaska in Wrangell. It was kind of a remote area. I went there and every time I called home from those same hours, she wouldn't respond. So yes, I got drunk and I said some things that I shouldn't have, and I'm really ashamed of the things that I said and that, that I have called her. So I've apologized a million times, but that doesn't make it right. Anyway, when I got back from Alaska, that last time, the locks were changed on the house. It was midnight, 1 o'clock in the morning. I got my truck, used the clicker to grab some tools out of the garage, and that's pretty much all I got. Stayed in a motel, and the house that we were living in, the reason I bought that house was because it was close to my father's house and he's older and I wanted to stay close to him and keep an eye on him. So now I'm forced to live with him because I cannot afford to live on my own because I'm paying $3,900 a month in spousal support and child support for one child. So I mean, as far as the 500 feet, I don't think that I'm breaking any kind of rules. I'm sure it's over the 500 feet, but I mean, that's just, I don't have anywhere else to go. I can't afford to be anywhere else. I'm low income. I'm on food stamps now just to survive. I haven't made any contact with my son since that day that she's referring to when I dropped him off because I picked him up at a friend's house. He walked from school to his friend's house and he called me and said, I can't get a hold of mom and it's pouring down raining. Will you give me a ride home? I said, sure. Make sure it's okay with your mom. And he says, I can't get a hold of her. I said, okay, well, then I'll come get you. So I went ahead and picked him up. I dropped him off. I didn't want to drop him off a block or two away because it was pouring down raining. Didn't think nothing of it. Went over to my sister's house and I got a phone call from the police department saying that, you're not supposed to do that. Go back over your restraining order. So I said, okay. From that day forward, I haven't seen my son. It's been a year. I haven't been able to see my son. No contact, no nothing. And I haven't broken any rules since that day. And as far as threatening her, that was the only threat was when I was drunk in Alaska, knowing that she was cheating on me. And like I said, I apologized to her via email and text. The next morning was like, I'm sorry, I didn't mean any of that stuff, but it doesn't make it right. So I don't think that the restraining order needs to go any further. I would like to see my son. And if it goes on for another year, it's only harming him,
How old is this child?
He just turned 14 in July.
14, okay. Correct, thank you. Ms. McAdams, just a brief reply.
Yeah, actually, I don't know where he's getting that. My son called me and I didn't answer because I've always answered unless I was at work and I couldn't answer, but I'll normally would text him. But also, I haven't kept his son from seeing him because of something that Mike and his father had called me and he hasn't been down there since. I ask him all the time, have you talked to your dad? He's like, no. I can't force him to do something he doesn't want to do. But I still feel that, the restraining order needs to go another year for safety until I can feel comfortable that he's not going to pull something and harass me or the guy that I'm now dating. I don't feel comfortable.
Okay. All right. Thank you. All right. I appreciate the input from the parties. So the way this case started, it looks like it was filed by Ms. McAdams back in April of last year of 2023. In her petition, she requested a restraining order that initially she asked for a do not disturb peace of myself and the child, and don't hurt or threaten. So that was there. So that's just kind of a straight request. There's not a factual basis. There wasn't a declaration saying this happened, this is why I'm scared or concerned. Proposed parenting plan was issued. There was the 90 days passed, a little past beyond that, and there was a motion for default that Ms. McAdams filed, which comports with what Mr. Wood was saying here, is that, there's this 90-day cooling off period or what have you. She made that motion for default, and that order of default was granted based on a request for a protection order without any rationale or basis of understanding why it was granted. What we know that thereafter, there was an order entered on July 14th, which was amended on the 28th of July. On the 28th of July, it added language, it added, pardon me, a distance or geographic requirement or what have you. So again, in that motion, there was information that's pretty vague and not specific. It just says, I want added to the order a geographic restriction, not come to the property. And it says, I have a current restraining order, but the stay away portion was not marked and I needed to have a certain distance. So that's all we know at this point. So the basis of the initial order is that I want an order. I think it's important for my safety. And then additional information is that I want him to stay away from my home. There's no basis or rationale for that. What we know since that time is that the order has largely been followed. There's been no arrests. Seems like there was a time where there was a drop off. It sounds like Ms. McAdams may not have been available because she was at work and the child was dropped off. Police were called and that was never repeated. So I think based on that, I'm going to deny the request for the extension of that order. Obviously, all parties to be on their best behavior and not be threatening each other, but the order terminates today. So let me just ask Madam Clerk, I believe is there a specific form, these protection orders have these new forms that are mandated by the state, and I just need to make sure that I'm following the correct procedure. Do you know off the top of your head, order? By the terms of the order itself, if you look at it, it expires in 12 months from July 28th. There was a motion extending that, the order extending that for a period of time. And that extension extended it to today's docket. So I think there's a specific order there. I'm not exactly sure. We'll have to find what it is, but I'm going to deny the continuation of that order. And by the terms of the order extending that order, it expires right now. So it's done. So obviously, and again, I emphasize that, all parties should be on their best behavior, not engage in any behavior that would be considered threatening or what have you.
Okay, I just don't see you. So that's what freaked me
Hey, Mr. Bradley, could you hit your mute for me, please? Mr. Bradley, can you hit your mute? Oh, thanks. Okay. So any questions, Ms. McAdams?
I guess if I get threatened again, or if he comes around, then I'm calling the cops, I guess.
Do you have any
Because
questions?
if this doesn't work out, then what do I do? Just file another one?
Correct. If any party feels, any citizen is free to file a motion asking for any type of restraint if they feel that their safety has been threatened. All right.
Well, I guess I'll be doing that.
That concludes the hearing.
Thanks.
Thank you, Your Honor. So how do I go about being able to go through to be able to see my son? How do I get back on the track with the every 2 weeks, the Saturday and Sunday, 10 to 2 or whatever?
Is there a parenting plan? Is there a parenting plan in place?
Yeah.
So if there's a parenting plan in place, it's in effect.
Do I need to have an escort with me so that, there's witnesses that I'm not doing anything threatening or violent? This is all a narcissistic behavior from her. The whole thing was a setup.
So as far as giving legal advice, that kind of delves into legal advice. What I would encourage you to do is you can check on washingtonlawhelp.org for some assistance. You can call the CLEAR hotline, You may qualify for that, you may not.
She went to every single free and low income place and submitted the paperwork.
Okay.
So I've already tried to get legal advice and help in there. It's a conflict of interest with all 5 that I've contacted.
Yeah, the other option would be to find a non-conflicted attorney to ask a question related to that. So what I understand at this point is that there's a final parenting plan that was issued on July 14th, 2023.
Correct.
And it says that alternate weekends, Saturday 10 a.m. to 2 p.m. and Sunday 10 a.m. to 2 p.m.
Correct.
So obviously, if there's concerns related to that and that's not being followed, then you could bring some type of motion.
Am I able to text or try to call my son at this point? It's been a year.
There's no restraints at this point in time, because what the restraining order that was in place that we just talked about is hereby dropped. So there's no restraint unless there's some other order out there that I don't know about.
Okay, would that be, so if I did try to contact him, she wouldn't be able to like call the police and say, hey, he's harassing or something just by a simple text like, hi son, I love you?
So courts are in the business of addressing facts that are presented to them that have happened in the past. Courts don't do prospective rulings.
Okay.
And I recognize that's probably frustrating for you, but I don't issue prospective rulings on what hypothetically could be.
And thank you for all your help.
All right.
Have a wonderful day.
Ms. Brummett, are you on the line? And Matthew Bradley, are you on the line?
Yes.
Great. You're here, and I'm happy to hear that. We were having difficulty communicating with you earlier, and now
Yeah, sorry about that.
Ms. Brummett doesn't look like she's on the line anymore.
Oh, I just talked to her. She said she was trying to get on, so.
Okay, let's see if we can get her here. Looks like you're on the line. Can you hear me okay?
Yes.
Okay. We're here. Mr. Lawrence is the guardian ad litem. He is on the line with us also. This is a review to make sure the parties have communicated and there's good communication lines between Mr. Lawrence and the parties. Mr. Lawrence, is there anything else that you're looking for today as far as getting your work started?
No, Your Honor. I have met with Mr. Bradley already. I've had phone contact with Ms. Brummett. We're meeting tomorrow. And I am going to do a second home visit on Mr. Bradley's home as the child wasn't there the first time. And so I'm expecting that he'll be back from church camp so that I can meet with him as well.
Okay, great. Appreciate the parties helping have good communication and moving things forward. Thank you very much. The other matter we're here for is a motion to adjust child support that's brought by Mr. Bradley. So let me.
Yes.
Yeah. Okay, and then Ms. Brown, did you receive paperwork related to that motion from Mr. Bradley?
Yes, and can I just say that when we started the case, I was not in agreement to Mr. Bradley's proposal, but we have came to the agreement of his proposal and his schedule.
Now, as far as your agreement encompasses parenting plan or child support. What does it encompass?
Just all of what he had said to the courts. Yeah.
Okay. Let's see. So what I know as far as from my vantage point, two things. One, that we're on for a motion for child support, and that Mr. Bradley indicates that his net income is about $3,300 a month, just shy of that, and that Ms. Brumley's net income is about $2,800 per month, a little bit higher than that. And then Ms. Brummett responded that there's no need to change the child support. That's kind of where I've left off in the pleadings. Anything to add to that, Mr. Bradley or Ms. Brummett?
At first, I was.
Oh, sorry. No, you can go ahead. Go ahead.
Okay, I was not in agreement with it all because it played with the schedule that we were currently doing, but his schedule that he had asked for was reversed to where he got the majority of the custody. So the child support order will technically kind of follow with that.
Okay. And so then if the parenting plan schedule that sounds like you've both agreed upon, if that's moving forward, then do you agree there should be a change in the child support?
Yes.
Do you agree? Have you seen what the figures would be? What the amounts would be?
No, we have not, but I currently at this moment don't have an income. So my income is now 0.
Okay.
And I would like to add that I would not like to have her pay child support if that's a possibility. Seeing as that I make a higher amount than she does, and seeing that she doesn't have a job, I wouldn't need the child support from her. I don't know if you take that into consideration or not, but
Yeah, it is taken into consideration. Let me ask the parties, are either party receiving any TANF or any type of state assistance?
I receive food stamps, but that's about it.
Food stamps? Okay. So there's some question of whether the state, the Division of Child Support, would be interested in being involved in the case. Sometimes they have criteria that requires them to be involved in a particular case, and I'm not sure if food stamps is a trigger that requires them to be present and participate or not. So on the issue of child support, what I have before me is just a simple 2-page document that says Mr. Bradley brought a motion to adjust the child support, and it should be adjusted, and it should be granted. However, I don't have a child support order or any child support worksheets that kind of break down the numbers of what the gross, the net, and what the specific dollar amount of child support would be, or any deviation from that amount. So sometimes there's deviations. So say it's a $250 support payment that one party has to pay, and there may be an agreement between the parties that say that there doesn't need to be a transfer. In order for there to be a deviation from something different than the child support worksheets, I need to have the worksheets. So that's kind of a long-winded way to say I can't finalize the motion to change the child support today without the worksheets and a proposed child support order. Because I'm in the dark. I don't have declarations as to your incomes. I don't have pay stubs. I don't have tax statements. I don't have bank statements, those things that I normally have to make those types of decisions. Obviously, parties can make an agreement as long as related to child support, as long as that's appropriate and the court approves it. So if the parties have come to some type of agreement, I would need a proposed child support order and also child support worksheets that list gross and net incomes and deductions and the like. And I think here in this instance, with those, once I think it would be Mr. Bradley's responsibility to prepare those orders, supply a copy to Ms. Brummett, and supply a copy to Mr. Lawrence, and also to send a copy to the Division of Child Support attorney. Her name is Barbara Russell, and she can be found in a number of ways. One, checking the Division of Child Support website. You could go to the Washington State Bar Association website and type in the name Barbara Russell, and it'll pull up an address, phone number, and usually an email. And so that way you could get those two orders or worksheets to her so she could review to see if the state should or should not be involved.
Okay.
Oh, it looks like she just provided that there.
Oh, perfect.
Can you see that in the chat, Mr. Bradley?
Yes, I do.
Okay. So you can give her a call and just figure out a way to get her that information.
Yep, that sounds great.
So what I'd propose doing is, Ms. Russell, do you have any comments?
Only that we've screened this docket and we didn't find any cases that automatically fall under DCS purview. So if one of the parents wants child support services, they need to make that request to DCS, and then their intake officers will forward that request to our office. They will deduct $35 a year from, if you don't receive public assistance, from the total child support amount for those services. And then my office would handle the matter.
So both parties can use that phone number to contact Ms. Russell if you have further questions about that.
Okay.
So moving forward, what I would propose doing is, today we're the 21st, we could come back on the 4th of September, which is a Wednesday at 9 o'clock in the morning. We would have proposed child support worksheets and proposed child support order that everybody would have available to them from Mr. Bradley. And if Ms. Russell needs to be involved, she'll be involved. If not, she won't. And we can look at signing those orders if it's agreed between the parties on that date. So are you both available on September 4th?
Are we able to make it 2 weeks out? Is that possible?
That would be 2 weeks. Today being the 21st, 28th would be
Oh,
one.
okay. Yeah, sorry about that. Okay. Yeah, just so that way I have time to fill out all the paperwork and turn it in and stuff.
Okay. Ms. Brummett, does that work for you?
Yes, that works. Okay.
Mr. Lawrence?
Yes, I don't plan to appear if the hearing is only on the child support.
Right. And it may be, it sounds like, and I don't know, the parties can tell me if you're going to delve into the parenting plan or possibly sign off on a parenting plan, because it sounds like there might have been some agreement there.
Yes, we did agree to approve my parenting plan. So,
Okay, would you, so if we want, we could, if the parties are in agreement with that parenting plan, again, all parties would need to have a proposed order of a parenting plan order. Mr. Lawrence would need to receive a copy. And then we'd have to be, then everybody would be here on the 4th to talk about the parenting plan and the child support.
from my understanding, I thought Mr. Lawrence already received a parenting plan. Is that not the case?
I don't know.
I have not received it directly, Your Honor. I'm sure there's probably the proposed parenting plan in Odyssey, and I haven't had a chance to look through yet, but I can familiarize myself with it.
Okay.
Okay.
Did you file it with the court, the proposed parenting plan?
Yes.
Good. Okay. So let me just look in here. Looks like that was filed on July 24th.
Yeah.
I will review it, Your Honor.
So that's Ms. Brummett's proposed order. It looks like there's probably another one here. There's another one on June 28th that was filed by Mr. Bradley.
Yeah.
So if those diverge or differ in any manner, then there would need to be a new proposed order that both parties agree upon. So you're saying the June 28th one, yours, Mr. Bradley, has been agreed upon?
Yes.
Okay, Ms. Brummett, do you agree with that?
Yes, so is if we make a new parenting plan together, can we sign it together and file it like that we both agree? Because isn't there a section that we are both in agreement on the parenting plan?
You can, yes, and Mr. Lawrence would need to receive a copy of it, and he would have necessary input also.
Okay.
So if you're going with the June 28th and everybody agrees that that's the proposed parenting plan you're looking to agree to and sign off on, then Mr. Lawrence has access to it. Then he will review it, and when we're back here on the 4th, that proposed order could be entered if there's no big concerns. But we'll hear from everybody on the 4th.
Okay. So we don't need to print out another parenting plan if he's going to receive that and review it?
I don't think so. Mr. Lawrence.
Okay.
No, I can get it off of Odyssey.
Okay, that sounds great. All right. So any further questions in preparation for the 4th?
Nope, not for me.
Ms. Brummett?
No.
Mr. Lawrence?
No questions, Your Honor.
Great. All right. We'll see everybody on September 4th. Force is coming forward.
Thank you.
And I'll ask if Jack Carnahan is on the line. Jack Carnahan. All right. Mr. Carnahan, if you're on the Zoom call, please make sure you're unmuted and state your name, Jack Carnahan. I'm looking on the participant list and I don't see Jack Carnahan listed. So Ms. Vorse, have you had any communication with Mr. Carnahan about his presence today?
There's a restraining order. We don't contact.
Okay. All right. Okay. So we were here I think we were here on the 7th of August. He was present.
Yes.
And he acknowledged on the 7th that he was served and received the pleadings for the hearing, but there was a lack of proof of service, which came in after the hearing.
He received the 4-page immediate ex parte, but he didn't receive anything else.
Right.
At the hearing on the 7th, but on the 14th, we had the sheriff serve him, which I believe there should be a return of service.
There is. Yeah, it looks like he was served on the 14th of August, and it was noted up for a motion for today. Well, from the last time we were here, we just set it over to.
Yeah, I don't know if he got served with the last time we were here, but you said there was no need for service since he was here.
Well, he was served on the 14th with summons and petition for a parenting plan, proposed parenting plan, financial declaration, immediate ex parte restraining order, a motion to appoint a guardian ad litem, the sealed confidential report. So it looks like you got all those documents on the 14th. So this is your motion for the restraining order, correct?
Yes.
Okay. There wasn't a filing from Mr. Carnahan in response to your pleadings when he was here. He acknowledged that he'd received the order itself, and we set it over to today, I think specifically for him to have provide some input if he wanted to.
That was my understanding.
Okay. 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 So Ms. Vars, you supplied a proposed order restraining order. And it includes yourself and also Jessica,
Yes.
the minor child. Okay.
Yes. My main goal is just to keep her safe.
Okay. I'll go ahead and sign off on that order. Take just a moment.
When will I be able to receive a copy of that order?
Good question. Madam Clerk, can you give some guidance on when that order would be available for a copy or pickup?
You want anything else?
I mean, like, when will it be scanned into the Odyssey? Couple days?
It's about 2-3 days.
Okay,
Your other option is to wait until the docket's completed and we can, and the clerk could help you with a copy of it.
okay, I may just get it in a couple days. I'm late for a meeting, so.
Okay. All right. So I signed off on the restraining order.
Now, do I need to carry that on my person at all times, like I did the temporary restraining order in case he comes into contact with me or my daughter?
Some people take that extra precaution.
Okay, so it's not discouraged not to do that, okay.
No, I don't think it's discouraged at all. No, it's, if there's a court order there, then if it allows police officers to more quickly ascertain the situation, that's helpful.
Okay.
Yeah.
Thank
Okay.
you.
All right. Thanks. 08, Gabriella Davison Wentz and Rocky Davison Wentz.
I'm here, Your Honor.
Okay. And that's Rocky Davison Wentz.
Yes, sir.
All right. Welcome to you, sir. And I'll ask if Gabriella Davison Wentz is on the line.
I'm here.
Okay. Welcome to you also. All right, I'll ask both of you. It looks like you both have, you're using some type of device that has a camera. Do you mind turning on your cameras, please? Okay, very good. Appreciate that. Thank you. All right, we're here today on a motion brought by Ms. Davison Wentz related to a motion for mandatory mediation. Mr. Davison Wentz, did you receive a copy of her motion?
Yes, sir.
Okay. Did you file anything in response?
No, sir. We decided to try to work it out without going through the dissolution of marriage.
Okay. So let me then turn to Ms. Davison Wentz. What's your vantage point?
We are going to try to work on our marriage. I feel like we've both changed and been able to come together and just figure it out instead of just giving up so easily.
Okay. So then, since this is on today for a motion requiring both parties to go into mandatory mediation, it sounds like, do you want to pull back on that motion, kind of cancel it, strike it, and not have that motion heard today?
Yes, please.
Okay. Any opposition, Mr. Davison Wentz, if I were to strike that and just say we're not doing anything today?
No, sir.
Okay. All right, I'm fine with that. So we'll strike the hearing today. The parties can proceed in the way you've described things, and the case will remain open until you do something, or usually like a year after. If nothing's happened in the case, you'll get a notice, what they call a notice of want of prosecution. They call it want of prosecution, lack of pushing the case forward. And if you want to continue the case, then you could file something at any time to continue the case. But if you get that notice and you don't respond, then it'll just be closed out and dismissed. It's kind of that kind of lay of the land there. All right. Any questions, Mr. or Ms. Davison Wentz?
Not for me, Your Honor.
Okay. Ms. Davison Wentz?
No.
Okay. All right. So the matter's stricken, and thanks very much for being here.
Thank you, sir.
Okay. Looks like both parties are present in the courtroom. We are here today on, so just making sure everybody, you're Humberto Cuevas?
Yes.
Okay, and you're Ms. Janice Cuevas.
Yes.
Very good. All right, we're here on Ms. Cuevas's motion for temporary orders. Looks like service was effectuated on the 14th of July and August 15th, including petition, summons, notice, a motion, proposed orders, sealed financial documents, tax returns, a declaration. And it seems like the main items that Ms. Cuevas is looking at is a request for spousal support or spousal maintenance, division of the cars, and payment of the mortgage and taxes, and insurance and utilities related to the home, and then life insurance and who pays for that. And when we were here last, Mr. Cuevas, on August 7th, you had indicated that you wanted to seek counsel and you wanted to set it over a month. And Ms. Cuevas said, no, let's do this fast. And so I kind of chose a middle ground and said we'd come back today to hear the matter. So that's kind of where we're at. And so, Mr. Cuevas.
As I say,
I do not have the money and I cannot miss so many days of work. But I decided to defend myself.
Okay. When, so with that decision as representing yourself, which not uncommon, as you saw, a lot of people are defending themselves or representing themselves. Did you file anything in response to what Ms. Cuevas was asking for?
No, I don't know. I have to file.
Okay, so generally that's what we do, because what's happened, Ms. Cuevas, she's kind of laid out her cards. She said, this is what I want. The cars should be divided this way. I think I should get this amount of support. And so I know what she wants and you know what she wants, but I don't know what you want and she doesn't know what you want. So it puts us on a little uneven playing field, if you will.
Okay, I have
So
to file the same papers and send it to her.
you're right.
Oh,
Right.
I don't know. I don't know that. I
Right.
don't know that. So no, I didn't do that.
So do you have a position? There's a couple of things that Ms. Cuevas was asking for as far as like the cars being divided up, the Subaru going to her and the Honda going to you. Do you agree with that or disagree with that?
No, she does the same every 5 years since we got the house. Couple of years into we bought the house. She refinanced the house and to pay her cars. And she did it again in about 10,000 times, 10,010 or 11. She told me, and at that time I have a debt too. We refinanced the house. And she told me this last time.
So
it was
do
16.
you agree
No, I
with
don't
that or
agree.
you disagree with that?
I disagree completely.
Okay.
I
And as
disagree because
as far as the insurance, she says that she
I don't even
she
know
wants
that
to
I have
pay.
insurance.
So don't interrupt me.
Oh, I'm sorry.
Yeah,
I'm sorry.
yeah, I'll speak and I'll let you speak, but when I'm speaking, don't speak over me.
I'm sorry.
So she's asking that she pay for the life insurance. Do you agree with that or disagree with that?
I agree with that.
Okay. And then she's asking that you pay for the mortgage and the taxes and the house insurance and utilities. Do you agree with that or disagree with that?
Do I pay?
That you pay?
Yes, I agree.
You agree with that? Okay. But you disagree on the cars, right? You disagree with what she wants regarding the cars. She says that she should get the Subaru and you should get the Honda, and you say no on that.
Oh, I agree.
Do you agree with that? Okay, so you agree with that, all right. And then regarding the $1,000 a month spousal support, do you agree with that or disagree
Don't
with
agree
that?
with that.
You disagree with that?
No, I disagree.
Disagree, okay. So 3 of the 4 items that were brought by Ms. Cuevas, it sounds like there's agreement. So if I understand correctly, and I'll just make sure that there's no questions. Ms. Cuevas is asking that she be in charge of paying the life insurance. So she would pay the life insurance. And you're okay with that, right?
Okay, I'm okay with that.
Okay. And that, and as far as paying the mortgage, the taxes on the house, the insurance on the house and utilities related to the house, she wants you to pay that, Mr. Cuevas. And are you in agreement with that?
I'm in agreement with that.
Okay. And then you're okay if you get the Honda and she gets the Subaru to drive?
I agree with that.
Okay. You disagree on the $1,000 a month spousal support?
I disagree with that.
Okay. Okay. So let me ask, I was hoping we could address all the issues today. So Mr. Cuevas, if you disagree, which you do, on the spousal support, she's laid out her reasons why $1,000 seems reasonable to her. I need to understand why you think that's unreasonable or why you disagree or 0 should be given or only $20 a month or whatever. I need to know what you want to say. So you have to file your declaration, write out why you feel what your position is, and then support it with your rationale or your arguments. Then you'd serve Ms. Cuevas a copy of that declaration and you'd file a copy with the court.
With the court.
Yep. And so then we would be back here in 2 weeks to address that. And I apologize that we didn't handle that today, but we made a little bit of headway. Are you available on September 4th at 9 o'clock, Ms. Cuevas?
Okay.
You're available?
Yes, I think
Okay.
so.
Then
need to check my calendar.
please.
Yes, sir.
Okay, so we will come
Yes.
back. Everybody's available. Great, thanks for confirming that. We'll be back on September 4th, Wednesday, 9 o'clock in the morning. At that time, Mr. Cuevas will have submitted his declaration regarding spousal support. He'll give a copy to Ms. Cuevas, and there'll be a copy filed with the court. And then we'll hear argument on that issue when we come back on the 4th of September at 9 o'clock in the morning. I'm going to take just a moment right now to write an order related to the cars, the mortgage, and the life insurance. So I'm just going to take a moment to write that. and then I'll let you know what it says. Ms. Cuevas, the life insurance policy, are there two life insurance policies, one for you and one for Mr. Cuevas?
Yes, sir.
Okay, thanks for your patience. The order reads, temporary order, respondent, and that's Mr. Cuevas, shall be responsible for timely payment of the mortgage, taxes, insurance, and utilities of the community home. Petitioner, Ms. Cuevas, shall timely pay the premium for the life insurance policies covering both parties. Petitioner, Ms. Cuevas, shall have use of the 2017 Subaru Legacy, and respondent, Mr. Cuevas, shall have use of the 2013 Honda Pilot. On September 4, 2023, the issue of spousal support will be argued and decided. So I've made it's in triplicate, so you can each have a copy of that order and you can leave with that, and then we'll see you on the 4th. Any questions, Ms. Cuevas, Mr. Cuevas?
No.
Great, thank you. We'll see you on the 4th.
Thank you very much.
52-0. If Landon, looks like Landon Floyd's present. Come on up and take a seat and just make sure you're in front of the microphone. That's great. Welcome to you. And then Cassidy Cram, are you on the line?
Yes, I am.
Okay, Ms. Cram is on the line. All right, we are here related to two motions brought by Mr. Floyd. Mr. Floyd made a motion for a restraining order and also a motion for a temporary parenting plan. And Ms. Cram, I think, is asking for child support or something of that nature, if I'm not mistaken. Is that accurate, Ms. Cram?
I'm asking for the approval of a separate temporary parenting plan.
Right. You have your own views on what the parenting plan should be as well.
Thanks.
Okay, so so it looks like as far as the service, Mr. Floyd served those documents to Ms. Cram related to the parenting plan. And Ms. Cram, did you receive those documents on about the 26th of July?
Yes.
Okay. And then did you supply a proposed parenting plan to Mr. Floyd?
Yes.
Did you get a copy of it? Okay. All right, so it sounds like everybody's got the information. The information is prepared, and we're talking about the child Stella, who's just over one. How many months is she? 13. Okay, all right, very good. All right, so I'll hear from Mr. Floyd. This is your motion, and I'll hear from Ms. Cram.
All right, I would like to start with I'm 100% okay with the visitations that I put into the order being adjusted, because I was under the assumption that those were going to be active for when, like, the duration between when she was served with the restraining order until now.
Okay. So tell me what that looks like.
So it was Fridays. It was 2 hours supervised visitation.
For Ms. Brown?
Yes. And I chose supervised visitations because it has proven to me that she is a flight risk. And
so now you're changing that a bit? Or is that what you were requesting, or
that's what
requesting?
is in the paperwork.
Okay.
But I thought that was okay.
Temporary period.
Temporary period.
Till now.
Right.
So now that we're here, what are you asking for?
I think it's important for her to have visitation for both her children. However, I also feel that there should be some mental health evaluations in order to, like, extended time frames of visitation. I'm worried that, once again, going to take off with Stella, and I won't know when I'll see her again.
Okay, so then you were talking about the change from the parenting plan of 2 hours supervised. I mean, what's the actual changes?
Well, I'm willing to be flexible with that, but I don't.
You have a proposal?
Not a written out one in a separate parenting plan.
Okay.
Or he's asking for what I had on.
So normally for me to make a decision with the parenting plan is both parties will come forward and say, hey, this is what I think is in the best interest of the child, and these are the reasons why I feel this visitation schedule is in the best interest of the child. It's kind of open-ended. You all are closer to the situation and know your child better than I ever will. So I rely upon the parties for you to advocate of what you feel is going to be the best interest of your child as far as visitation. So generally look for telling what their thoughts are, because I think they're in a better position than I to at least have some perspective. So it's going to be good for the child.
So I would want to remain the custodial parent as I am set up and established here in Longview. Just as Stella has been since before the day she was born. And since before she was born, I've been the sole provider working more than full time. We want to make sure that her bills are paid. There's eviction notices and stuff in here from us moving to a place that we couldn't afford and not getting any financial help despite begging and pleading for help with paying bills. And instead, I was met with denial of and getting a job.
So where are you at? Support? Do you have a place now?
Yes. Currently, I'm still at that place. I'm going to be moving with my mom up to Winlock for just a couple months until I can pay back some debts that have accumulated over the last year living in debt.
When do you plan to move to Winlock?
By the end of the month. And I don't plan on being there for more than a few months.
And that's your mother's home?
My mom's home, yeah.
Who else is in that home?
Her husband and my two sisters.
How old are your sisters?
9 and 13, almost.
And is your mother's husband your father?
No.
Okay, so that's your stepfather?
Well, yeah.
Okay. Has Ms. Cram met your stepfather?
Yes.
Okay. So what's your proposal as far as visitation?
I want Ashley to attend for mental health evaluations in order to, I'm fine with working with, every other weekend, first, third, whatever. But as long as she stays through with her mental health evaluation, goes through with her treatments.
Okay. So are you looking to alternate between, say, like a Friday to a Sunday?
Yeah. Okay.
And you wanted them, previously you asked for them to be supervised, or you asked for them to be supervised?
The supervision was more for ensuring that she would not leave with Stella again.
Okay. So unsupervised is your request? Or no?
Yeah. I mean, as a parent, I can't imagine having all the time, having somebody watching over my children. I don't want that.
Okay. Fine.
But with the parenting plan being in place, yeah, a little safer, so there's more legal backing if she does do it again.
Okay. And then as far as decision making, your proposed order, you have as sole decision making for school and educational purposes and non-emergent health care. Does that fit into that pre-category before we came here today, or at least that's appropriate?
I still feel that that's appropriate.
And is there a location where things would occur?
Well, she proposed in her proposal that the meeting place would be in Hood River, but I'm fine with meeting somewhere, but I don't feel that it's fair that he gets to leave a couple hundred miles away and then I have to
So you're wanting a mid-expanse location?
Right.
Okay. Anything else you want me to know? So you work graveyards, is that correct?
Yes, sir.
Okay. And then when you're working or sleeping, who's watching the child?
I have my aunt, and then my mom, and then my biological mother.
Okay. Ms. Cranberry is concerned about alcohol consumption of one of those individuals. Anything about that?
I mean, specifically, when she's talking about my biological mother. I mean, I drinks, but she might have a beer or two while she's out with the kid. But I mean, even myself and Cassidy, even we've done that on multiple occasions. We've been drunk with said mother, both of us. So like, I don't feel that it's fair for her to hold that against my child could.
Okay. And are you still asking for a restraining order? Or is that part of the family before we get to this?
That
this
was
point here?
that was more so for until we got here.
Okay. And then let me just ask a little bit about child support. It was represented by Ms. Graham. Your gross is about $3,700 a month, and the net about $2,600 a month, and our net's about
I'm not entirely sure where she's getting her financial records from, because as far as I'm aware, he's only been gone since July 18th. But she hasn't worked since May of 2023. She's not had employment anywhere.
Too close with your
what?
Is she close in her estimate of what your income is?
Yeah. My income is fairly accurate.
Okay. Right. Okay. Anything else about why your parenting plan should control versus the parenting plan of this plan?
I mean, I'm the one that's been the responsible person to the best of my ability, given the circumstances that I've had to deal with and maneuver around since before Stella was born.
Prior to Ms. Graham moving, who would you say was the primary custodial parent? Who's the parent that, tell me what the parent is responsibility for after the
Well, I work graveyards, but I also work their 12.5 hour shifts. So I leave at 7 p.m., get home. Well, I leave at about 6 p.m. and then I get home about 8 a.m. So I come home and try to sleep because I only have so much time. And then basically we're just getting ready to, or getting up to get ready to go to work.
So you generally 6 hours or something, or sleep?
It varies. I have trouble sleeping sometimes, so sometimes I sleep 8 hours, sometimes I sleep 2, and then spend quite a few more hours trying to rest and sleep some more.
Any other information you want me to know?
During my days off of work, I would spend time, like, I don't know, hard to describe what I do as a parent. Just spend time with my child, take care of her, make sure she's fed, change a diaper. No, it's just parental duties. It's not something that you really think about. Not something that I really think about. It's just something I do.
Anything else you want me to know about?
I think that's about it.
What we'll have Ms. Graham. Ms. Graham, you want to address the issue of your parenting plan?
Yes, so the protection order that was originally filed and approved was approved on a Wednesday, and Mr. Floyd did not come and pick up until that Friday, the following Friday, so 2 days later, which shows to me just a lack of actual concern for safety or need for the protection. but more of a way to just receive Stella back. You can see very clearly in my proposal and my evidence within my proposal kind of how parenting went. My concern is Stella's schedule. I know that it seems very inconsistent based on the communication that I've had. And I know that, you know, the nights that Mr. Floyd is working, she's not staying at home in her own bed, which I do understand that you do what you need to when you're working like that. But it's just a lack of consistency. And then my lack of working is because I've been finishing my bachelor's degree in teaching. And because I was not working,
Process of finishing the degree.
yes.
Where in the process are you?
Right now, I'm actually in my last week of classes this week.
Okay, so the coursework will be completed, and then is there student teaching?
I was also student teaching during that time,
Okay,
during
so
the last year.
you get your degree and you'll apply for jobs.
Yes, I actually have a training on the 26th of this month to start at the local school district here.
So you have a job lined up on the 26th?
Yes.
Teaching position?
Yeah, I will be substituting so that I can work on my master's degree. But I will be substituting 4 days a week because it's very easy to have consistent subbing jobs right now.
Okay, so if you're working, who's going to be providing childcare or follow your parenting plan?
I currently have Stella on a waiting list at a daycare in the town that I will be teaching in, but also I have my my younger sister will be providing that care until she gets in.
How old's your sister?
She'll be 20 next month, so she's 19 now.
And is she available full time to do that?
Yes.
Okay. Can you speak to the issue of, you raised some concerns about mental health? Do you want to address that?
Yeah, sorry, I raised the concerns or he did. Which ones?
I think you both did.
Yes. So his concerns, I believe he said that I shut down and didn't deal with him. I think, I don't remember his exact verbiage, but that was a lack of me wanting to fight and argue. It was not shutting down. And with his own, he has in the past been medicated for, I believe, depression and anxiety. But I do know that he has not been medicated for that in quite some time, and I think that would be very beneficial for him. And I know that there is an evaluation that he was supposed to take for his custody arrangement with his 5-year-old daughter, and I do not believe that was ever done.
Okay. And then can you address, there was reference to another parenting plan case where there was indications that you're relinquishing your parental rights? Is that accurate?
Right. So that is my own 3-year-old son, and that is not Landon's son at all.
Right. But are you relinquishing your rights to your 3-year-old son?
I am, yes.
Can you tell me a little bit about that, please?
Yes, I can. I have fought in court with my son's dad for the past 3 years. And it is financially not something that I can keep up. Not something that I can continue to fight for the next 15 years. And I do not see there ever being a break in the court cases, no matter how they go one way or the other. But financially, I could not keep up with that. And it was making my livelihood arrangements unstable because of how much of a financial strain it was.
Okay. So financially, that's that fight continuing for another 15 years caused you to make a decision to say, I'm terminating my rights with my child.
Yes.
Okay. I'm a bit unsettled by that, and so if you have any additional explanation, I'm happy to hear from you.
I understand that. My my son's dad has 7 years of age on me, and he's very established in life and in his career. And he was very upset when him and I split up. And I was under the impression when my son was born, my 3-year-old, that we had agreed to 50-50 and that's how we would parent him. And then I was served with a bunch of paperwork, and basically that was not the case. He had just been kind of lying to get information on me and to try and make it harder for me. And it was affecting my mental health. So I suppose Mr. Floyd is right in that way. The fight with my 3-year-old's dad was affecting my mental health, and was something that was really taking its toll on me and my ability to continue to go to school and to continue to parent Stella as well. And I did not think that was fair for her.
I guess let me get one final question. Kind of the elephant in the room is, I often hear parents say, I'll do anything to fight for my child, recognizing that things may change, you get a job, you become more established, financially secure, and then there's, hopefully an opportunity that, that power imbalance will become maybe in greater parity, and you're able to wage a better fight. But that, you hang in there until the time comes. So that's kind of the question I have is why not hang in there and continue to have rights to your child? So that's kind of the elephant in the room in my mind. Can you address that?
No, I understand that. And the rights have not officially been signed over yet because it is a very huge decision. And it's something that I have really weighed for a long time because I very much thought that I would fight forever. I'm a very maternal person. But I don't see there ever being, I don't foresee there ever being common ground, or I don't see the power balancing out. And there are some stipulations in the paperwork that eventually we can revisit. That will be filed on the 10th, I believe, of September.
But was seeing the child, visiting with the child.
Yeah. Basically the stipulations are that eventually we can revisit me having the visitation with the child, and seeing the child, but until we revisit, then there will not be.
And if your rights are terminated, what right do you have to have any visitation with people?
So the rights, I don't think it's an official termination of rights. It's more of a relinquishing power, or control over that situation.
Would you have any visitation? There's the kind of the agreement you're looking at. Would you have any visitation with the child going forward?
Not until it was revisited, no.
Okay. All right. Thank you. I appreciate you asking answering those questions. Anything else you want me to know about regarding the parenting plan?
Sorry, I'm looking at my list here. Not that I know. I have a job starting the end of this month. Stella shows a lack of consistency, and I was the primary caregiver up until this point, I had never gone more than one night without seeing Stella, and now it's been almost a month. Sorry. And I have a lot of support over here, consistent support, to help me continue to build and provide better for her. And that is it.
Who do you have besides your sister?
So I have my younger sister, and then I also have my mother, and then my older sister as well.
And Aragon, that's where you're living?
Yes.
What's the time travel from there to Longview?
It is about 4 hours.
Mr. Floyd was asking for a midpoint in between the 2 hours.
Yeah, I think that's in the Dalles.
Yeah, she, in her proposed plan, Hood River, but I feel that even a 2 hour drive for fairly, so if it was to go in any direction, I don't feel that it's fair that I would take like drive 4 hours in total over a weekend, or 8 hours in total over the weekend, because we decided to leave what she had set up here. What Stella had set up here.
Under your parenting plan, what's your proposal?
Under my parenting plan?
I thought you put I thought you said a midpoint.
Oh, I didn't have a midpoint in there. I mean,
you did or did
would
not?
be willing to pick one, but I'd actually be willing to do anything for my child, but I just don't think it's fair that I would have to drive 2 hours there and 2 hours back.
Okay. Ms. Graham, any additional thoughts on the parenting plan?
I think what I have suggested is very fair and allows for a lot of flexibility with his weekends and his job schedule. And I think it's the most realistic plan that's been proposed up to this point.
All right, thank you. So as far as the restraining order, it sounds like Floyd wanted that for a time period up to this point of the proceedings, so I'm going to deny the restraining order that was issued previously, that expired on its own terms now. And we need to turn to the parenting plan. So the parenting plan, it sounds like Stella's pretty young, still 13 months, and yeah, Mr. Floyd was working. It sounds like Ms. Graham was going to school and wasn't working for a period of time, and now sounds like she's landing a job and will be starting a substitute teaching, I think here in the near future at the end of this month. Mr. Floyd has been working in excess of, he describes it in excess of full-time, working graveyard shift, kind of a long shift, 6 p.m. to 8 a.m. with travel time. That's a long period of time.
7 p.m. to 7:30 a.m., but I have to.
That's why I said with travel time.
You're right. Sorry.
Yeah, no, it's okay. And so then he gets home, he sleeps best he can. It's difficult to sleep when you work graveyards. Some people can do it, other people it's a challenge. And so he does his best to sleep. And during the time that he's working and sleeping, somebody's caring for the child. So I'm assuming, I'm giving my ruling at this point. Sometimes I think when I give my rulings, people perceive that as an invitation to speak more. I've given each opportunity a lot of time here today. I've read your parenting plans and your input. So I'm giving my ruling at this point. So he indicates, during that time he's working full time and sleeping. There's not as much parenting time during this time frame. Ms. Graham seems to be the providing a greater amount of care and has been providing that care up until just recently with the issuance of the restraining order. So part of me says Ms. Graham should be the primary custodial parent. What is the large elephant in the room is the indication in the other case just recently of a desire to relinquish parental rights to a 3-year-old son. And I have not walked in Ms. Graham's shoes. I don't know her life. I don't know the life that she was living or the interactions with her soon-to-be ex-husband and the potential trauma and difficulty that she lived under or would continue to live under. I don't understand that. And I don't also understand an idea of relinquishment where somebody gives up their parental rights, where they're terminated, that there's some right that's triggered in the future to revisit that with visitation. My understanding of relinquishment is that rights end, and I may be misunderstanding this, so let me just double check with Ms. Graham. When the phrase relinquishment is used related to parental rights, that means there's a termination of parental rights, meaning you cease to be mother for all legal purposes. Is that what you're talking about?
I suppose, yes, the way I worded it was not great.
So what does it mean?
So basically for now, until he is closer to adulthood, I will, yeah, my rights will be relinquished.
All right. So to me that's, like I said, I don't understand the situation of Miss Graham. I don't understand who's dealing with her ex-husband. I don't understand that. It may be so severe that for her own mental health and well-being that she has to do that, and even taking into consideration the mental health and well-being of her child. I assume she is. To me, that's a drastic step. A drastic step in that people are in dependency proceedings where they've been alleged to have neglected their child through their drug abuse or their own substance use disorders, and they try to get back into the child's life, overcome those difficulties they have, and they fight and fight and fight and fight, and to relinquish without the knowledge or a legal right to see a child, even if it's for a period of time, for during the week, or maybe even just during the summer, perhaps. Parties live across country, and a father and mother lives, is the non-primary custodial parent, and they only get to see the child during the summer, but at least they get to see the child during the summer, or any time they can make arrangements to get there. But the wholesale just, and I want to be sensitive about this, the wholesale relinquishment of parental rights just strikes me as odd and drastic. And recognizing that Ms. Graham has been, at least in my mind, the primary custodial parent of this child, but Stella, caring for the child here, there's no indications that Stella was abused or neglected or not well taken care of. And yet it's that relinquishment is hard for me to overlook and just ignore. It's like it's right here in my face. It's hard to see around that. So I'm going to nominate the father as the primary custodial parent, with Ms. Graham having alternating weekends, the first, the third, and the fifth weekends of each month, from Friday at 5 p.m. until Sunday at 5 p.m. The parties will meet at a midpoint exchange location. That's the Dalles. That's where it'll be. If it doesn't have to be mathematically exactly half point, generally there's kind of some wiggle room. So it's a public place where there can be an exchange, cover if there's rain or what have you. But that's where that'll occur, and that weekend visitation will occur. The same thing goes with the decision. The elephant in the room is really large, and so I'm going to hold off on making that joint and make it a sole decision making as to Mr. Floyd. I know there's concerns about movement of the child and evictions. That's a concern. Stability is important for the little people. So I'm going to reserve on child support until we have more information related to child support and new incomes and the like. So what I'll encourage the parties to do is to once we know what your income is, either party can note it up for a motion for child support and ask for the child support order to be entered. So let me just go through just a moment the parenting plan that was supplied by Mr. Floyd. And make some adjustments to it, and I'll let you know what's while I'm doing that, I'm going to appoint the guardian ad litem to investigate the case. I'm going to make it a county pay case at this point, meaning the county will pay for both portions and for both parties. I'm going to ask the clerk to give us the next 3 names of individuals who are on that guardian ad litem list. You each have the opportunity to swipe one if you so choose. and then we'll just go from there. So Madam Clerk, if you just please share those three names. Yeah, so we had a previous case where one party struck one party, one of the guardian ad items, and there's a potential that the other party may strike one of them. I think we just skip over those three and then go to these three. So I'll ask Mr. Floyd, you're the petitioner, if you want to strike any of those individuals.
I don't know anything about him, so I mean, right, I mean, that ad item is similar.
Okay. Ms. Graham, do you want to strike any of those individuals?
No.
Okay, I'll appoint Ann Height to be the guardian of item. I'll prepare an order that reflects that ordinance. And then she'll be in the packet, she calls it. It's like a big packet. You'll need to receive that and promptly return it to her. And make sure that if you change your address, anytime you change address, you need to update the court with a new address. Otherwise, the court and all parties will just send the documents to the most recent address. So if you change address, update it with the court and make sure we have that. We'll take care of that and I'll take that file. Okay. Give me just a moment. I am going to require Ms. Graham to undergo a mental health evaluation, and if they require any treatment, to follow through with that treatment, whatever it may be. As I indicated, decision making at this point, and again, this is a temporary order, fairly early in the game, will be to Mr. Floyd, related to education, school, and non-emergent health care. Thanks for your patience. So the parenting plan relates to Stella, and I've indicated that neither party has any of the issues that are related in A and B under 3 as far as abandonment, neglect, and abuse and the like. So there's no limitations. I am requiring the mental health evaluation of Ms. Cram, and the health and non-emergent healthcare and school and education decisions are limited to Mr. Floyd at this point. And that Mr. Floyd would be the custodial parent, and Ms. Cram would have first, third, and fifth weekends from Friday at 5 p.m. until Sunday at 5 p.m. They'll exchange at the midpoint between the residences of each. The summer schedule is going to be the same as that schedule I mentioned. The holidays, at this point, I'm going to leave that open, and the parties can figure that out if that's appropriate, but I'm not going to make any rulings on holiday plans. And then there's some warnings in here as far as relocation. You need to make sure you read that, are very familiar with that. And I've signed off on that. So this order, if you want to get a copy of it, you can check with the clerk's office, possibly get it to today, or, in 2 or 3 days, you can check with the clerk's office and they can mail you a copy. I'm reserving on the issue of child support until we get more information from the parties, and the parties, I'll put the onus on you to file some type of motion to address child support. Either party can do that. Just make sure you file and then serve copies to the other party and note it up for a hearing. So that's kind of where we're at. I am denying, if it wasn't clear from earlier, that the restraining order that was in place that expires on its own terms here today. So I'm not continuing that. So any questions from you, Ms. Graham?
No.
Thank you. Thank you for being here, Ms. Graham. Mr. Floyd, any questions?
I think I may have just missed the pickup times for the weekend visitations.
I said Friday, 5 p.m., Sunday, 5 p.m.
Great.
All right. And so again, yeah, this is a temporary order. Ms. Height is on the line. She was appointed as a guardian ad litem. She must have caught wind of that. So thanks for being here. So both parties are here. Ms. Height, do you have any comments or requests of the parties?
No, Your Honor, thank you. I just wanted to know if you were going to generate that order appointing.
Yes.
Great, thank you.
All right. Thanks very much.
I did have one more question
Go
for
ahead.
Ms. Cram herself.
We'll take the public. Go ahead.
Do you know what time you would be out of work?
What?
Make my schedule work around the Friday and Sunday, but specifically for Friday, you get out at 3:30. You're not really going to be able to realistically make it there.
Yeah, I'll allow the parties to discuss this offline.
Okay.
Thank you.
Just communicate with each other and kind of figure that out. Okay. All right. Thanks very much. That'll complete the hearing. Jack Bissig, are you on the line? You're here, you're in person. Come on up and take a seat, Mr. Bissig. All right, and then Megan Gibson, are you on the line?
I am, Your Honor.
Okay, welcome to you. And then Ms. Call, you're here?
Yes, good afternoon, Your Honor.
Good afternoon. Let me just check one item here. All right, we're here on Ms. Gibson's motion for contempt related to parenting plan and missed visits. And we were here previously on the 7th of August, it looks like. And at that time, we set it over to today. And let me just ask Mr. Bissig if you filed a response to this, because the court file doesn't show that a response has been filed.
Yeah, I was able to do it yesterday, and I was also able to give Megan a copy of it when she was served. But I got it all scheduled and filed yesterday.
Yesterday, okay.
So if you want to just continue it out and get some time to go through the system, and I'm okay with that.
Okay. All right. And so it's okay. So you got it to the clerk's office yesterday. Ms. Gibson got a copy of it. Ms. Gibson, did you get a copy of his reply?
Yes, I got it yesterday afternoon.
Okay. Ms. Call, I see that you're on the line, and I was just double checking on. Sometimes on my Odyssey edition, sometimes it'll be clear the guardian ad litem has been appointed, and I'll show up. Other times it's not. You've been appointed in this case.
I have, and actually, Your Honor, I wanted to point out that there has been a guardian ad litem report filed that has yet to be reviewed. And I think that some of these concerns that Ms. Gibson has may be addressed within that report.
And that's your report that was filed back in March.
Correct, yes.
Okay. That's something that we should probably review. Mr. Bissig, did you get a copy of that? Do you have a copy of that?
Yes.
Okay. Ms. Gibson, do you have a copy of that?
Yes, I do, Your Honor.
Okay. So with the filing of the Mr. Bissig's reply, I haven't read it. Ms. Call, would you, Mr. Bissig, would you mind getting a copy to Ms. Call so she has a copy of your reply to the motion?
Yes.
Okay, that'd be great. So
I have not received copies of anything from either party. I can retrieve those things on Odyssey. I just was made aware that this issue had come up. I've been encouraging Ms. Gibson to file a motion to get the report reviewed. I know Mr. Bissig spent some time in jail recently, so this has gotten more complicated since the filing of the report. But I think that review will be helpful in some of these issues.
Okay. So let me touch base with the party. So the motion for contempt, I think, Ms. Gibson, do you have any strong objection if we were to set that matter over so I can read Mr. Bissig's reply to your motion?
No, I don't have any objections.
Okay. So let's take a look. What I'd like to do is set it over 2 weeks so we can address the motion for contempt. I'm looking at a September 4 date at 9 o'clock in the morning or 12:30 in the afternoon, depending on when we get to it. And on that date also, we would review the guardian ad litem report that was filed on March 14th. So that means if you read over Ms. Call's report and either you agree with it or you disagree with it, I want something in writing from each of you, so I know what your respective positions are, if that's what she's recommending, if you think that's a good idea or if that's a bad idea. So I want you to, so you'd submit something to the court, give it a copy to the other party, and send a copy to Ms. Call so she knows, she's aware also, so everybody's just in the know. And that would need to happen sooner rather than later. So I would encourage you to have that submitted by next Wednesday. So it can get into the court file and be uploaded so I can read it and be aware of what your positions are. Are you comfortable doing that, Ms. Gibson?
Yes, I do have two questions for you, Your Honor.
Okay.
So one, our statements on her proposed plan, do we need to submit that or have that served to the other party as well as Ms. Call, or just to Ms. Call into the court?
Everybody needs to know. So you'd give a copy to Mr. Bissig and Ms. Call and to the court. Yeah.
And then my second question had to do with pushing the date out. My only concern with Wednesday the 4th is I do help take care of my little sister. I get paid to do so from my parents. Both my little sister and mine and Mr. Bissig's daughter are going to be starting kindergarten on the 3rd. And we aren't sure yet on where, if they're going to be in, it's going to be half days. I'm not sure on whether or not the girls are going to be in the mornings or the afternoons. And so pick up and drop off is going to be a little hectic for this first week of school happening starting the 3rd. I'm not 100% sure on what our schedule quite is.
Would you be comfortable if we came back on the 11th of September, Mr. Bissig?
That's fine.
Ms. Gibson, September 11th?
That works for me, yes.
Ms. Call?
That's much better for me than the 4th, yes, Your Honor.
Good. All right, so we'll come back on September 11th at 9 o'clock in the morning. We're going to address the contempt motion, and we'll have read what you've submitted. And then both parties are going to submit information, your response to the guardian ad litem's March 14th report. If you need to get a copy of that, check with the clerk's office. But you'll both write your response, submit it to the court, give a copy to Ms. Call, give a copy to the court, and then we'll go from there on the 11th and make some decisions. Any
Thank
questions?
you, Your
No, no, no.
Ms. Gibson, any questions?
Nope, that was it. Thank you.
Paul?
I'm good. Thank you, Your Honor.
Thanks, everybody, for your patience. We'll see if we can get to you much earlier in the docket next time.
Thank you.
Thank you.
Thanks. All right, that marks the end of the docketed matters for today on the docket. So I'm in a position to end the Zoom call. Thanks, everybody.